Good evening, and welcome to the February 24th meeting of the Indian River County Planning and Zoning Commission. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First thing tonight, I'd like to introduce our new members. To my right is Todd Bragnano, Amron Homes, local county developer and real estate contractor. Brad Emmons. Brad is CEO of Vero Insurance. And Dr. Jonathan Day. Dr. Day is professor of medical entomology at the University of Florida. So this is our new group tonight. And returning is Jens Tripson and Sam Zimmerman.
And yourself.
Okay. First thing we do tonight is we elect chairman and vice chairman. And at this point, I will hand the meeting over to Melissa.
I'm sorry, I didn't know we were doing that tonight, so I'm going to ask for some help from staff, because I've never done this before.
I think what you want to do is call for nominations for chairman.
Okay. I'd like to call for nominations for chairman.
I nominate Donna Keys as chairman.
Thank you.
Second.
And do they just do a roll?
Just any other nominations? And if not, elected by acclamation. And now the new chairman will hold the vote for the vice chairman.
Okay. Do I have any nominations for vice chair?
Sam Zimmerman. I second.
Any further nominations? All right. Sam takes over as vice chair then. Thank you, gentlemen. Okay, first item on the agenda is the minutes of the meeting from the December 9th meeting. Do I have a motion?
Move to approve.
Second.
Any discussion? All in favor say aye.
Aye.
Motion carries. All right. The item on the agenda next is, this is a quasi-judicial item, which means anybody who wants to talk about this, make any presentation or participate in the discussion, please stand and be sworn in. This is the David Damero's Salvage Yard Junkyard.
Please raise your right hand. Do you swear or affirm that any testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Thank you. Okay, public discussion. David Damero's appeal of a decision by a community development director that a non-conforming junkyard salvage yard be used at 4410 45th Street has ceased for more than 1 year and cannot be reestablished. Mr. DePloy?
Madam Chair, before staff presents its case, I would like to note for the record that I did send to attorney for the appellant as well as the board and staff a memo that I wrote yesterday regarding non-conforming uses, and Darcy has that. She's going to enter that into the record. And I do want to make one caveat to this memo that Bruce and I discussed this morning. When I say that there's a presumption of correctness on the part of staff's decision, by that I don't mean as to their determination of facts, but as to their interpretation of the law. So the facts still need to be determined by this board, but their interpretation of the law is given a presumption of correctness. It's sort of a technicality, but Bruce did want me to point that out, and I wanted that to be on the record.
Do you also want us to call for ex parte communication?
Yes, if you've had any ex parte communication, you should reveal that at this time and also state whether or not it will influence your decision here today.
So has anybody had any discussion with either the applicant? Okay. All right. Mr. DeBlois?
Thank you, Madam Chairman. For the record, I'm Roland DeBlois, Chief of County Environmental Planning and Code Enforcement. As you have indicated, this is an appeal of staff's decision that a non-conforming salvage yard use has ceased and cannot be reestablished. Mr. David Damero is the registered agent for 45th Street Commerce Investments, which is the listed owner of the subject property. As far as location, the property is located near the corner of 43rd Avenue and 45th Street. The address of the property is 4410 45th Street. There's two adjacent parcels, combined approximately 9.23 acres. This slide on the overhead shows the current zoning of the property. In the dark purple is what's called IG, General Industrial. Then the light purple is IL, Light Industrial. This, as you can see in the outline of the property, there's the two parcels. The westernmost parcel, which is the linear strip parcel, is in the IG zoning. In that zoning, junk and salvage yards are allowed as a special exception use. In the light purple IL property, which makes up about 6.8 acres of the overall property, in that light industrial, junk and salvage yards are not allowed in that zoning district. Essentially, in this property, the history of it is that salvage yard use was established prior to the current zoning. A review of zoning maps, it appears that around 1985 there was a conversion of an old zoning of M1, which was a general industrial for the overall that applied to the total property, was switched to the combination of IG and IL, thus the current nonconformity on the east parcel. I have a series of a few aerials that were taken that the county has access to for various times. The first one I'm showing was taken, it's an aerial from December 2005. I show this to illustrate that at that time the aerial is showing that there's vehicles, it's apparent from the aerial there are vehicles on the property, assumingly junk vehicles, that you typically would expect to see on an aerial for a junk or salvage yard. And it's also, as you can see, similar to or comparable to an established junkyard to the west. The next aerial I'm showing is from September 2007, which is the next available aerial series that the county has. You can see there's a substantial change visually in looking at the aerial on the property, and as it shows, virtually all those vehicles that were on the property in December 2005 have been essentially removed, which appears to reflect that the salvage yard use was ceased and cleared off the property. The next aerial I'm showing is April 2008, which again, it appears that the property is still in the dormant mode or doesn't have the extent of vehicles on the property. Again, you can see as a reference, the active salvage yards to the west of the property. And then December 2008, again, it does not look to be significant difference as far as the vehicles being on the property compared to when it was clearly active back in 2005. Just a chronology on how this all came to be and why we're here before you. Back in May of last year, county staff received complaints that there were some buildings being restored and it appeared that vehicles are being brought onto the subject property, which appeared to, just on its face, to be a reopening of a business that hadn't been open for a while. As part of that complaint response, there was an interagency inspection of the property, including code enforcement staff, environmental health department, drainage engineering enforcers, and so on, and reviewed the property. As a result of that investigation, including building staff, it was concluded that, yes, there were violations out there, particularly related to building work without permits and other violations. And as a result of that, county code enforcement staff issued a notice of code violation. In June and August, the agencies allowed a period of time for voluntary compliance, and there was some action towards that. Also during that period, the code board authorized staff to schedule an evidentiary hearing from the code enforcement standpoint. In September 2010, Mr. Damerow met with county staff, and at that point it was discussed the issue that's here today on the issue of the cessation of the non-conforming use. Staff provided its information that based on review of the aerials and just general observations, it appeared that this could be an issue because of the zoning. We also asked Mr. Damerow to provide information that would support his position that essentially, as he explained to us, although it has been at reduced levels, his position is that it has not discontinued for a continuous year period over time, and it still should be allowed to be a junkyard salvage use. As a result of that meeting and the allowance for him to gather information and provide it, staff postponed its code enforcement hearing. In October, after further communications, staff gave Mr. Damerow, representing the ownership, a formal letter indicating staff's position. At that point, it appeared from our perspective that this is a cessation of nonconformity for a period of more than 1 year, and therefore the use could not be reestablished on the east parcel. As a result of that formal written notice, Mr. Damerow, through his attorney, submitted an appeal of that decision. Finally, from November through to the present, the appeal process had been delayed, as agreed to by staff and the appellant, to allow time for submission and review of additional information and to accommodate the appellant's schedule. And now we're here today for the appeal. Specifically on the code section that we're applying in this case is code section 904.081 on cessation of nonconformities. And this is right from the code section. If for any reason a nonconforming use of land, a nonconforming structure, or an establishment having a site-related nonconformity ceases operation for a continuous period of 1 year or more, all nonconformity shall be considered terminated and shall not thereafter be reestablished. In looking into this matter, when we initially looked at it and also looking at information that we gathered over the time period, we looked at historic aerials, and I've already kind of given you an overview of some of the areas that we've looked at. We also looked at occupational tax license records, and as we investigated it, and as it's shown in your backup material and agenda item, Mr. Damerow did in fact keep a renewed tax license for AAA auto salvage at this property from 2005 to present. We also looked at property appraiser records, and what we found was in August 2009, the property record cards indicate that there was an appraisal done, which is done periodically by property appraiser staff, and under...
That piece of evidence, I think...
Well, Mr. Barquette, okay, but please do it at the microphone. Thank you.
Bruce Barquette for the applicant, and so far I have no qualm with what Roland has said, but the property appraiser is not here to talk about his records. That's completely inadmissible here, saying it's irrelevant. We don't know on what basis he makes those records. We don't know who entered that record. We don't know the criteria they used to make that record. So I object to it for the record. I object to that being...
I think the board can consider it. This is an administrative hearing. Hearsay is allowed in administrative hearings. And you can take judicial notice of the fact that I'm assuming these are taken from the official property appraiser's records.
But my point is, we don't know what criteria they used to make that record. We don't have anybody here to say who made that entry, what they based it upon, whether they did any inspection of the property, what the value of that entry, or what its purpose is.
Well, I think if we were, I think they can consider it for the limited purpose of they're not. Staff is not trying to introduce it as their ultimate proof of a cessation of nonconformity, but as part of its package. And I think under the rules of administrative evidence,
why don't we ask staff what they think they're admitting it for?
Okay.
Roland, what is the purpose of that record?
We're just showing that it's a public record that indicates a land use code of vacant industrial.
That some unknown person in the property appraiser's office made some determination based upon unknown criteria that some condition of the property existed. on that basis, I don't have any objection, but I mean, no, that's not true. I do object. That is completely irrelevant and inadmissible. In court, that would be inadmissible. And you're here as a quasi-judicial body, and you should act like a court.
Well, I'm going to note for the record, this is an administrative hearing. Rules of evidence as apply to administrative hearings apply. You should consider it in the limited context in which it's being introduced. And I think, Bruce, you and I, if whatever happens here today, if this happens to go to the county commission, you and I can talk more fully about how things are introduced or how objections should be handled.
All right. Thank you.
Thank you, Mr. Burkett. Mr. Boyce?
Okay, thank you. We also reviewed documents recorded in the public record, and as included in your backup, specifically we looked at a settlement stipulation that's recorded in the public record, which I'll explain more in a moment. And then we also looked at business receipts from a period of January 24th, 2007 through July 10th, 2009, which I understand were submitted by Mr. Damerow, and as I understand it, they were not intended to be, according to him, all receipts for his business, but a sampling of receipts. Well, we did review that. And also he submitted an unsigned affidavit where he essentially says that the business has continued operation, and that is in your packet backup. Something that we didn't include in your backup, but we did look at, and I'm bringing it up because it is something we did, it is in the public record, is in June 2007, there was a pre-application conference file on record in the county planning office that Mr. Damerow had a pre-application conference for what were called Damerow warehouses, which essentially we're not saying that that's conclusive evidence of anything, was just information that we have, that at least in 2007, Mr. Damerow was exploring property use other than the salvage yard. In looking at these pieces of information on the aerials, again, we've already shown those on the overhead and they're in your backup, but essentially what we found were, it showed vehicles stored throughout the property in December 2005, which you'd expect for a salvage yard. However, in the 2007-2008, the property was essentially, it appeared from the aerials anyway, devoid of that vehicle storage that was prominent throughout the property in 2005. We also looked at on the occupational licenses. Again, we verified that Mr. Damerow had in fact kept the occupational license renewed since 2005 for a salvage yard at the property. We took that for what it is. Essentially, it's evidence in his favor, but we don't see it as a conclusive evidence that it means it was in fact continuously used as such. He just kept his license up, and we acknowledge that. As far as the property appraiser record, we've talked about that. On the recorded settlement stipulation, which is again in the public record as part of a circuit court action, which the appellant was involved with, there's a stipulated settlement signed on May 14th, 2009 by Mr. Damerow representing the ownership, indicated in, quote, this is from the stipulation, defendant, which would be 45th Street Commerce Investments, will work with reasonable due diligence to reopen the property as a salvage yard. So we looked at that and said, this means something. It implies that it wasn't opened at the time as a salvage yard. And again, we did look at the business receipts and the affidavit that Mr. Damerow submitted, but as it turns out, and this is something we looked at, the time frame of the receipts and the affidavit, it conflicts within that settlement statement we just referenced, and that the receipts were during a period at the same time, and that statement that was signed said it would be reopened, which implies it wasn't open. So there seems to be a conflict there. In looking at the overall information we got, let me just say first that We asked Mr. Damrow if he was willing to submit any and all information he had that could prove to us from a staff perspective that it was a continuous use, and then if we agreed from that information, then we wouldn't be in this appeal mode. And one of the things we asked for example, were income tax returns. We did not get that. What we did get was essentially what you see in the packet, which are the sampling of receipts and the affidavit. And based on all the information that we gathered, looking at some of the conflicting information, and the fact that we didn't get all information that we felt would help to make a decision, we worked with what we had. We concluded that, based on all that, despite the affidavit information, the preponderance of everything we looked at indicated that the salvageur had appeared to cease, particularly between the period of September 2007, which was the date of that aerial that first showed it without the vehicles throughout, and then between that time and the August 29, which was the date of that property appraiser record. But in any event, in 2009, we also had that other information on the stipulation settlement statement, which that was in May 2009. But between that period, which is more than a year, we feel, from a staff perspective, concluded that the use had ceased during that time period. So that's where we're coming from. This is an appeal under the county's code section 90207. That's the county section that sets forth the guidelines for appeals. And under that section, there are essentially 4 areas where the Planning and Zoning Commission is to make findings. First would be essentially that staff follow the appropriate review procedures. And in this case, staff feel we did follow the appropriate procedures. We looked at all the information we had. We asked the respondent to provide any information they could provide to justify their position. We went through a procedure, and we feel we did act in an appropriate manner. Second area is, did staff act in an arbitrary or capricious manner? And again, we feel that we did not act arbitrarily or capricious. We followed logical review procedures. We looked at all the information we had available. We asked for information, and once we had all the information we were going to get, we were timely in our decision, and it was based on the information we had. Next is, did staff fail to consider adequately the effects of the proposed use upon surrounding properties, traffic circulation, or public health, safety, or welfare? And again, we feel that we did not fail in that category. Essentially, what we looked at was the reestablishment of the use, particularly as a non-conforming use, and how it would affect the adjacent properties. This property in particular abuts the North Gibbet Community Park to the north. It abuts residential lots to the east, and that's essentially why, from staff's opinion, the zoning was changed back in 1985, is to provide a transitional zoning buffer between the heavy IG use to light industrial to get to those adjacent uses, which are essentially incompatible with a junkyard use, and that's essentially why the zoning was changed. That being said, we understand that if there's a legal non-conforming use that is continuous and was legal when it was established, there's a right for it to continue. However, in Chapter 904, under 904.02, which gets into the purpose and intent of the county's non-conformity regulations, it specifically says one of the purposes and intent is to promote the phasing out of non-conforming structures, uses, and characteristics of uses and combinations thereof via specific conditions and limitations as set forth in the chapter. And one of those specific conditions is that if it discontinues for a year or more, it ceases. So we looked at that, and that's really what we're looking at, is meeting the intent of phasing out uses that legitimately discontinue. So we did not fail under that guideline. And then finally, fourth guideline, did the reviewing official evaluate the issue with respect to comprehensive plan and land development regulations? I've already referenced the land development regulations that we've looked at. We looked at the zoning. Use allowances, we looked at the nonconformity regulations. We also looked at policy 10.1 of the future land use element of the comprehensive plan, which again reinforces the issue of nonconformities and that they cease after they're discontinued. In the end, staff's recommendation on this, based on everything we've presented, is that we recommend that the P&Z make a finding that staff determination did not fail in any of the 4 areas outlined in section 902.07 and deny the appeal and wholly affirm staff's determination. And that's our presentation. Thank you.
Thank you, Mr. DeVois. Does anybody have any questions of staff?
Yeah, I do. Roland, in all your reviewing, did you talk to any of the adjacent property owners? Was anybody able to say whether there'd been active business going on or not?
Yeah, we have, and I think you'll see that there are some that are going to speak to that today. Okay. There's at least one.
And then one other question on the receipts, and maybe this will go to the applicant or the appellant, I don't know. Looking at all the receipts for sales, and there are a few, but not many, but the law doesn't seem to address that. It's, if they have one sale in a year, it seems like they would be able to maintain it, but I don't know. Do you not have to charge sales tax on used items? I don't have any idea. It's been 20 years since I bought a part from a junkyard, so I don't know.
Let me just say that we didn't mention this, but we did learn in looking into the matter a little more since the staff report was written that it appears on the state level through the State Department of Revenue there's a requirement, what they call second-hand dealers and secondary metal recyclers license requirements. And again, we didn't get that information, or we didn't have the opportunity to we didn't get the information to know if they had one or not for this business, but at this point we haven't. That's a bit of information we don't have.
You don't have it?
But my indication is that if there is a legitimate active salvage yard, they should have that license.
I have a question. How long has this existed as a salvage yard? How long has this been here? I mean, about.
Well,
how far back has this been operated? How long has this property been used as a salvage yard?
We know it's been there since at least 1984, probably longer before that. So it was clearly legal when it was established.
It's 20 or 30 years.
Yes.
Okay.
Any further questions of staff?
I have one more question, and this is probably best directed to you. Is the standard is the standard a preponderance of evidence? What is the standard of proof here for us to determine this on?
The standard of proof, and you're the trier of fact here, is to determine whether the evidence presented by both sides is competent and substantial. In other words, that the evidence given to you is competent and substantial, and that competent and substantial evidence, one party or the other has to establish by a preponderance of the evidence, which would be 51%,
right,
that they've established their case.
It's preponderance of evidence.
Preponderance.
Thank you.
Mr. Barquette?
You have to open.
Thank you, Madam Chairman. Bruce Barquette.
I guess we'll open the public hearing before you speak. Thank you. Thank you for reminding me. This is a public hearing. We're going to open the public hearing. Mr. Barquette is first, obviously.
Thank you very much again. Bruce Barquette, representing the applicant. Just wanted to clarify, I think you guys asked a couple of really good questions, but we'll just have to disagree with you just a bit. The standard of proof is preponderance of the evidence, but it's not whether one side or the other prove their case. The burden is upon the staff to prove a cessation of activity for a continuous 1-year period. It's not my burden to prove that we didn't do that. The burden is upon the staff to prove that activity ceased completely for one continuous period, 1 year continuously, 365 days. So that is the burden that we're addressing tonight. And just with that, so I believe that your question and Mr. Tripson's question brought that point to bear. I wanted to say that, and I wanted to tell you how we're going to proceed. Mr. Vatunak is going to talk to Mr. Du Bois a bit about his testimony, and I'm going to bring Mr. Damerow up, and I'm going to ask him some questions and bring some evidence. So that's how we'll proceed unless you have an objection. So with that, I'd like to introduce Mr. Vatunak.
Thank you, council members. Good evening. My name is Doug Vatunak, Collins Brown Caldwell, 756 Beachland Boulevard, representing the appellant. And I want to preface these questions that I have for Mr. Du Bois with a statement that I hold him in the highest regard. I hope he's not annoyed by my questioning.
Obviously, this is going to be a tough one if you have to preempt the conversation with that.
That's right. Well, I'm trying not to be too tough on it.
Jeez.
But my first question, Mr. Du Bois, is what specific period of time are we looking at for cessation of use? I gather that it's from your staff report that it's September 2007, sometime in there, to December of 08. Is that right?
It's from, as we indicate in the report, it's from, let me see here.
I think it's to current.
I believe it was through August 2009. So it was the time period from the 2007 through August of 2009.
And the August 2009 date, that's the date of that settlement agreement?
Well, May 2009 was the settlement agreement date. The August date was the date of the appraisal and the property appraiser records that indicated vacant industrial.
Okay, I'll restate Mr. Barquette's objection to that. The settlement agreement, does that say anywhere that in it that the salvage yard was closed?
I think that's implied.
It implies that through the indication that it says it would be reopened.
And nowhere in there does it say for what period of time it might have been closed, does it?
Correct. It
Okay.
does not.
Your staff report also indicates that code enforcement received a complaint from someone in May 2010. Now, at this hearing today, we're talking about property that used to be zoned that would allow this and was downzoned to industrial light. And so there was a legal nonconforming use as a salvage yard. Can you tell us whether the complainant who complained operates a salvage yard in the same IL district?
Well, the code enforcement records indicated it was an anonymous telephone call that initiated the complaint.
So we don't know if this person might even be a competitor of Mr. Damerow and AAA and
I don't
40
think that matters. That doesn't
Fifth
matter.
Commerce.
That doesn't matter. It was anonymous. We're not going to make speculation that it was a competitor.
Right. Well, then the answer is no, we don't know who this person was or what his biases might be. That's the point I'm trying to make.
Well, can you make a point then of what that matters?
Well, we don't even know. Well, it would, if he made a complaint, there may be ulterior motives to him making that, and his notion that this might have been closed for a year may be for self-serving purposes and not based on the truth. But I'll move on. Your staff report, you indicate you've reviewed historical aerials. Is there any way we can go back to those on the television sets here so that I can discuss those?
Yes.
Do you know who took these aerials?
No, I do not.
Do you know what time of day they were taken?
No.
At the bottom of left of the aerials, it says the information on this map is taken from reliable sources. However, the accuracy of the map is not guaranteed. Is that right? Did I read that right?
Yes, I believe that's what it says.
Okay, and we don't know these reliable sources they're mentioning here, do we?
I have no indication other than...
Do you know how long about an aerial survey of the county would take to take aerials of the county?
No.
Okay, and these aerials, they have dates at the bottom right. I don't know if everybody up there can see that. I have copies if you'd like them. You can see that? They are handwritten on the maps. Do you know who wrote the dates down?
I did, and that's based on our county's GIS database system, which indicates when the date of the aerials were taken.
Okay, and you use the word circa to describe the dates. Is that because we don't know exactly what day of the week or day of the month these aerials were taken, do we?
Correct.
Okay. Do you have a specific number in mind of cars or vehicles that you have to have on your property to be a salvage yard? Because when I look at some of the aerials during the time period we're discussing here with regard to cessation, let's start with the September 2007 aerial. That's right around the period I think the staff report indicates the cessation is alleged. And if you'll take a look at the, I don't know if it's called a panhandle or what, but there appear to be just above this what looks like a residential development that also borders on this 611. Just to the north of that, do you see what I'm seeing here? There appear to be a number of automobiles there in the corner. Is that what you're seeing?
You're talking about in this area here?
That's right, yes.
Yes, there could be vehicles.
Hard to tell what it is.
Can you make an attempt to count those? Does it look like maybe 4 or 5?
That sounds like a reasonable estimate.
Okay, and there are some other things on the property at this point that appear to be vehicles. There's a yellow item toward the bottom of the site.
In this area?
Yeah, that's right.
I would assume that's a school bus.
Okay, and then just below that there appears to be something else. So there are some vehicles on this property during this time. Isn't that right?
The aerial appears to show that, yes.
And then let's take a look, please, at the one that's dated April 2008. I'm seeing markings on this one that I didn't see on the other one. Do you see what I'm talking about? There appear to be tracks from vehicles on this one that, if you switch back to the other one, don't appear in the other aerial. And I'm wondering if you know what those are. To me, it seems like there could have been some heavy vehicle traffic between this time period on the site. Can you comment on that?
Yeah, the aerials speak for themselves. I do know that, just from my experience of reviewing aerials, that depending on the time of day, the season, what certain features show up better in some aerials than others. The resolutions are different. So as far as to be conclusive that this is clear evidence that there was every traffic and path established between the two aerials. I don't necessarily see that as a clear conclusion.
But we don't know the times the aerials were taken. It could be the same time of day, same light. And it could have been because cars were dropped off. I mean, inspectors weren't at the site every day for the time period we're discussing, right?
Correct.
Okay. I don't know if you have the affidavit and receipts on the television. If you could pull that up, I'd like to inquire about that just a bit.
We can set up.
If we have an overhead, that would work too, because I have copies.
Roland, we just looked at the 07 and the 08 over aerials. Could we see I think there was one in December of 09? Thank you. Oh, December of 08. Okay. Thank you.
It's this here. It's December 08,
Yeah.
I believe.
Did you see anything on the December? Well, I guess it doesn't really matter at this point.
No.
Just make sure it's changed.
Okay.
This is the December 08 and another version of, it's the same aerial.
Did you have any comments on that one?
Yeah, just one. I wanted to point out that in the upper right, there appear to be the same white shapes, although they may be hidden by tree cover at this point, but there still do appear to be 3 or 4 vehicles there in the upper right. Is that fair to say?
They're overgrown by paper.
In the same place you circled the ones before on the older aerial. In fact, they might even be the same cars. Sure.
And that'd be a reasonable interpretation.
Okay.
You look at that sequence of photos.
Okay.
Mm-hmm.
And I just want to do it with my pen here.
You could do it
Right in here, these white things, and
right on top of that.
right over here. And then let me take you this affidavit here. And I don't know if it's necessary to go through this whole affidavit in the interest of time, but when you were testifying about the affidavit, you noted that it seemed to contradict, I think was your position, that it seemed to contradict, if these invoices are verified, that some of these invoices are dated for the period for which staff believes that the use was ceased, right?
Right, and again, in particular, the settlement stipulation had a signed date of May 2009, which again indicated that the salvage yard use would be reopened, and that falls within the period of the receipts that was shown from January 2007 through, I think it was July 2009.
And the receipts demonstrate salvage yard use. They're not receipts for selling candy.
No, they're not receipts for selling candy.
Did any of the interagencies inspection crew ever go inside the buildings?
I do not know. I have seen photographs of the buildings. back in last year when this was first looked into, and they were essentially open-sided, at least the ones that, the photos I had seen, but otherwise I do not know if they went inside the building.
Okay. Just a couple more. I want to turn now to the definition sections in the ordinance, in the land development regulations. And in particular, I'd like to show you the definition of junkyard. I'm going to read this.
You want to tell the commission what section specifically? Do you have the section number?
We're talking section 901.03, the section that begins definitions in alphabetical order. And the section just above it actually states it's the purpose of this chapter to maintain the definition of terms for all land development regulations. So, and I'll read this. Tell me if I read it right. Junkyard. The use of any land, building, or structure for the parking, storage, collection, processing, purchase, sale, disassembly, demolition, or abandonment of junk, including scrap metals or other scrap materials, waste paper, rags, used building materials, old household appliances, junked or otherwise inoperative vehicles or machinery or parts thereof, and other type of junk. See also automobile wrecking yard. Did I read that right?
Yes.
Okay. So if we were to follow that definition, if there was evidence that cars were being processed for parts on the site, or that vehicles had been abandoned on the site, or that that vehicles were being disassembled for parts, or that parts were being sold out of this parcel, that would indicate junkyard use according to that definition, right?
Yes, it would seem so.
Okay. And you said earlier you don't know how many vehicles have to be abandoned on a property to be a junkyard, right? Well, let's skip that. Let's go to, it mentioned in that definition of junkyard the definition of automobile wrecking yard, indicating that they're the same. Look at that one here. And I'm reading the definition of automobile wrecking yard from the same section. Automobile wrecking yard, in parentheses, also see junkyard. A site utilized for the dismantling or wrecking of used motor vehicles or trailers, or the storage, sale, or dumping of dismantled or wrecked vehicles or their parts. The presence on any lot or parcel of land of 2 or more motor vehicles, which for a period exceeding 30 days have not been capable of operating under their own power, and from which parts have been or are to be removed for reuse or sale, shall constitute prima facie evidence of an automobile wrecking yard. Did I read that right?
Yes.
And would you say that the aerials we've seen today that show what appear to be multiple cars in the upper right-hand corner, is that prima facie evidence that this was used as an auto wrecking yard during that period? According to the definition.
According to the definition.
Okay, and I'm sure your inspectors never actually tried to start these cars or anything to see if they were operative.
No.
Okay. I think that's it. No further questions. Thanks for your patience.
Thank you, Mr. Vatunak. Is there anyone else in the audience that would like to Mr. Parquet?
I'm sorry, I might not have made it clear. After Doug, I was going to bring Mr. Demereau up to testify.
Oh, thank you.
Pardon me? No, you stand here and I'll go to that mic. Okay. Again, I'm Bruce Barquette for Mr. David Damerow. And, David, would you tell the board your name and address, please, for the record?
My name is David Damerow. My address is 812 Northwest 1st Street, Fort Lauderdale, Florida.
And Mr. Damerow, are you the owner of the property we've been talking about tonight?
I am.
Okay, and when did you buy the property? June
2005.
2005, yes, sir. And what was the condition when you purchased it?
It had cars on the site, and I bought it from a man named Mr. Bosch, and it was operating junkyard.
And what was the condition of the vehicles on the site? Were they usable to you for a junkyard?
Some were, some weren't, but they were old vehicles and didn't have a real lot of value for parts because a lot of the parts were stripped of them.
So what were your plans for the property and for those vehicles?
I was going to crush most of the cars on site because, frankly, people were only interested in parts, 1 to 5 years, 6 years old. They weren't interested in 15 to 20-year-old vehicle parts, at least not to the level that I wanted to bring the junkyard to. So I crushed some of the cars. Okay,
does that explain the absence of vehicles on the property and the absence of a lot of vehicles on the property in the photographs Roland showed us?
It does.
Okay, and Doug kept mentioning and Roland kept agreeing to the presence of certain vehicles in that sort of northeast corner there. Are those in fact vehicles?
Yes, they are.
Okay, and have they been there continuously?
Well, on and off, yes.
Okay, and are they junk vehicles?
Yes, they are.
All right. And have you maintained your occupational license to run a automobile salvage yard or junkyard on this facility since you bought the property?
Yeah, and I guess that's what I was a little more surprised about than anything else. I've always kept an active license. We had some ideas to do different things with the property, but as the economy fell off, I had bigger ideas to create a bigger pick-a-pay or create a better facility than what's there currently. I actually even brought a fellow up out of Fort Lauderdale that runs a pick-a-pay facility down there, in a first-class facility, nice and clean and nice fences and nice buildings and whatnot, to expand it. And that's what we really had tried to start to do, and that's when, for whatever happened, they shut me down for about 4 months. And
could you tell us
what is a pick-a-pay?
Pick-a-pay is a type of a junkyard where people can come in and they pay a fee and they come in and they can pull their parts off automobiles or cars or whatever you have to offer for sale, and then they can pay for just that part.
So it's still a junkyard or scrap
Yes,
salvage
ma'am.
yard?
But it's a different type of junkyard.
Could you just, you were explaining to me, Mr. Cameron, let me just, you were explaining to me how the internet has changed the junkyard business. Can you explain that a bit to the board and how it affected this property?
Yeah, probably over the last 5 years in particularly, people can now go and advertise their parts online, or people would call and ask for parts online. You could go online, buy the parts online, and then make a transaction, almost like a junkyard broker, without having a large inventory on any particular property. And that certainly changes the model of running a junkyard, where you don't have to have 1,000 cars sitting there rotting away, when you can go ahead and buy what you need when you need it, and make the sale from that.
And is that how this has been operating in this facility?
Yes, that's. I couldn't see spending $100,000 on more vehicles and let them sit there, especially when the economy was sliding like it was. So we used that as a model to conduct our business.
So let me get this on the overhead, so I could get some help with I don't know, whatever we call this thing these days. Actually, there it goes. I'm sorry, can you read that off over there? I'm just asking if you can see it. If not, you can come over here and we can
No,
look at it.
I can. I just have to put these on.
Old age is hell, isn't it?
Go ahead.
If you look at the entry on, that my finger's out on March 8th of '08, it says that there was something illegible, 76 Toyota Camry rear towed to Vero Yard. Now, would that have been in response to an order?
Yeah, I have also a tow yard out of Fort Lauderdale, and I thought what a great way to take parts from there, which I have an inventory of, and be able to go ahead, since I don't have a salvage yard there, I have a tow yard, and take the vehicles from there and bring them up here to go ahead and sell parts and do whatever up here.
Well,
and you can't do that there.
That particular job have been in response to somebody ordering a part or requesting a part from you?
Exactly.
Okay, let's go to the next one, because that might be easier to understand. That one's on April 3rd of '08. It says a 2000 Chevy, a 2000 Chevy was dropped in the Vero Yard destination, I think from Orlando. Well, why don't you explain it to me?
Yeah, the tow yard across the street from my building down there is called Safari Towing, and so we use them often enough to bring parts back and forth. And we had an order for a 350 Chevy engine, and so they brought it up there from our site down in Fort Lauderdale.
Okay, so just so I understand, well, it says Orlando. Did you? It says Orlando dropped something.
Well, that's where it was going, to Orlando.
Okay, so, but again, well, how was your yard used then?
Well, that's where the transaction transpired. The buyer came over, picked it up, and that's the end of it.
All right. What about the next entry, the 1999 Honda towed from Orlando to Vero?
Yeah, that would have been a wrecked car purchased out of Orlando, brought over to Vero, and then people needed some parts on it.
And then what would you do with the shell? What would happen after the parts were sold that were ordered?
Get rid of the shell, sell it for scrap.
And how much do you get paid for scrap like that?
Well, it fluctuates. At one point when I was crushing the cars over there, we got about $110, $120 a car, and now probably scrap is up to $400 a car.
So, just so I can understand this, you will get an order. You will locate the vehicle from which to take that order, like the 350 Chevy engine.
Sure, you can go on a Copart, which is a website, and a lot of the different junkyards have parts advertised there. You buy the part there and then resell it.
And that would be, to actually get the part out of the vehicle, you would haul it to your Vero junkyard, strip the part, convey it to the person who ordered the part, and then sell the remainder for junk?
Or take the part off and just do the transaction up there.
Okay.
And there's a lot of different ways we've done it. Just depends on what it is. And
now, as Roland indicated, these receipts and this that I'm looking at here is just a compilation I've done. The actual receipts are attached. They start in January of '07 and proceed to December of '09. I'm sorry, July of '09. Do they represent transactions that actually occurred at the Vero junkyard?
Yes.
Okay. Was there any 1 year period, any continuous period of 1 year when no transactions happened at the Vero junkyard?
Never.
Okay. Moving on. I have some photos here which I'd like you to explain, please. Could you tell the board what this is?
That's a front-end loader.
And how is that relevant to your business?
That was used to pick up cars and trucks and whatever and move them around the site.
Has that been on the site continuously since you purchased the property?
Yes, it has.
Okay. Did you purchase that as part of your acquisition of the property?
I did.
Okay.
Mr. Barquette, can you tell me when that photo was taken?
I don't know. Mr. Damero took it. Mr. Damero, did you take that photo?
Yes, I took that photo 2 years ago, maybe 3 years ago.
Okay, so we don't
they-
have a date. All right.
No, but
No, I couldn't
but your
tell you.
testimony is that it's been continuously on the site since you purchased it in 2005. Is that
Yes,
correct?
yes, it has.
The difference, and I understand your question because Doug was asking Roland about the photos, the difference is Roland has no idea who took those photos. Mr. Damero took this photo and is testifying to you that the property has been on the site continuously.
Thank you.
Now, what is this, Mr. Damero?
That's my roll-off, rollback tow truck.
And how is it used?
I pick up cars and from Fort Lauderdale a lot of times, and then I'll bring them up there.
And what are we looking at here?
That's Jimmy's trailer, and we would haul cars around on that as well.
Can you identify, who is Jimmy? Tell the board who Jimmy is.
Jimmy originally signed a lease to lease part of the junkyard under my umbrella back in '07, I believe, and then he got hurt and kind of morphed into more of a general manager than a tenant.
Okay. Jimmy, could you stand up for the board, please? Thank you. If y'all have any questions for the manager, the property manager, he's here.
Thank you.
Mr. Damero, what am I looking at here?
That's an engine.
And where is it?
It's under the covered shed there on site.
Is it a salvage part?
It is.
Would it be available for sale or use in your business?
Sure.
Would it be visible from an aerial photograph?
No.
And what am I looking at here?
Those are computers out of cars. They sell for about $450 a piece.
Okay. Also on the inside?
Yes.
And are they sold?
Not yet, but I hope to.
I guess I asked that inartfully. Does this represent inventory that you buy and sell?
Yes.
Okay. And have you been doing that? Has there been any continuous one-year period since you purchased the property when you have not been doing that?
No, and like I said, when our business fluctuates up and down, and we don't do a big business, but we still do some business because I was ambivalent about what I really wanted to do and where we were going to go ahead and transition this to. I spent a lot of money purchasing equipment that I really wanted to gear up on that site, and unfortunately this issue came up, and so I was not able to bring it out there to use it yet.
All right, Mr. Damero, I'm going to show you another photo, and let me just ask if it would be fair to say that, irrespective of the individual parts, these photos collectively, do they represent sort of what the inside of your warehouse looks like and has looked like during your ownership of the property?
Yeah, there's parts in and out, in and out, in and out. Not the same parts there, but in and out.
Okay.
Yes.
All right, thank you. What am I looking at here, sir?
Tires. Tires for sale.
Ah, okay. And what about behind the tires? What am I looking at there?
2 motorhomes. One's a motorhome in back for parts, and the other one is more or less a security.
So this motorhome is being stripped for parts?
Yes.
And this picture?
Some vehicles, yes. Some vehicles, no.
Okay. Samra, I'm going to... Well, you had mentioned a lease. Let me just put a lease up here for you. Tell me how your leasing operation works.
I would lease an acre to a particular tenant that wanted to use the property as a salvage business. He would work under my umbrella to try to generate more revenue.
Now, this lease recites recites a sum of $1,000.
Yes.
How often is that paid?
Pardon?
Is that a monthly?
Yes, $1,000 per month.
Okay, so a tenant can also use your site to have vehicles brought in, stripped and sold?
Yes, and they did.
So you can, and they did. And how many of these tenants have you had in the 5 years you've been on the site?
I think 3.
Okay. So that you can, so simultaneously, more than one operation can be going on under your umbrella.
Yes,
And that's what's been happening?
that's what did happen.
Mr. Barquette, while you have the lease up, normally in a lease it says what the property is going to be used for by the tenant. Do you have something in the lease that says
There
that?
you go. Good
Thank
job.
you.
I'll just read it because it says use. Lessee shall use and occupy the premises for junk and salvage yard devoted solely to automotive trucks. And while we're at it, let's just go back to the term. Did you tell the board what the term of that lease is, sir? Can you read that?
From 2008 to 2010.
June of 2008 to May of 2010. Thank you, sir.
Mr. Barquette, do you have anything that shows that the tenant continued to lease that property during that time? Was he paying?
Well, I've got this gentleman to tell you whether he was or not.
No canceled checks or?
No, I've just got the testimony.
Did he fulfill the
burden of proof
lease
isn't on us.
till May 2010?
No, he fulfilled the lease till, I'd say October, November 2009.
Thank you, sir.
When you say fulfilled the lease, does that mean he stopped paying you in 2009, or he was no longer doing any business? Or how long had he done business on
He
the
stopped
property?
paying me.
Okay. Was he still doing business on the property up until the time you obviously
I had to
had him
evict
leave?
Yes, he was doing some business. I mean, I didn't pay attention necessarily every day of what he did and what he didn't do because he leased an acre from me so he could do what he wanted to do. As long as he wasn't contaminating the property and was being clean about it, then I was okay with it.
While he was using the property, were you also using it?
Yes.
Okay.
Thank you.
Any other?
Did you have any other sublease arrangements during that time?
Prior to that, I did, and I think there was one other lease that we had, and I was trying to find it. I couldn't find it to bring it here today, but we had one other one. It was $1,000 a month as well.
Mr. Emerald, I think I'm getting close to the end here, but I'm going to put on the board, this is going to be hard to see. Can we zoom this in?
I can do it from here if you just...
I saw that enough.
Okay, that's good. That's good. What I'm showing is a Florida Power and Light account number. If you take a look at that number, it starts 289-880559, and it's for the subject property. Is that correct, Mr. Daniel?
It is, and there's an address just below it.
Okay. The address is just below it. Now, remembering that account number, if we turn to the next page, you see the same account number right there, 289-880559. And the reason I point that out to you is because this page does not have the address on it, but it is the same account. And if you, the significance of this is, I will tell you that in the past, your board and your staff have relied upon electric bills to determine whether a property has been abandoned or not. And this electric bill will show that from a period of starting in, this particular history goes from December of 06 continuously through 11 of 08. There's been electric utilities used at the site. Now, there are periods of time when there were 30 service days. There was 1 month when there was even 32, which is a Gregorian calendar's challenge. I'm not sure. And there are a few days, and there seem to be some months when there were none. But there is no 12-month period when there was no electric power used at the site. The site was used intermittently and almost consistently during this entire time. And as I said, that has been used by the county in the past to determine whether a property has been abandoned or not. If it hasn't had any power, it's been abandoned. Well,
Mr. Barquette, do you have any evidence for dates like 2005?
no, ma'am, but that's not at issue here. The only allegation against us is that from September of 07 to some indeterminate period in 09, there was a continuous 1-year period. So I don't have any.
That just shows that there was electric going to the property. It doesn't show that there was a business in operation.
Oh, well, do you think an aerial photograph that's taken by an anonymous person on some unknown date showed that there was no business?
Actually, a $10 electric bill shows me that there's not very much business going on.
Well, Ms. Keys, I mean, I can argue with you, but what about the
I can address that.
59 kilowatt hours that were used in October of '08.
You don't need a lot of electricity, ma'am, to run the junkyard. Normally you have air tools and you have freestanding gasoline-powered compressors and whatnot to take stuff, and then you also do it by hand.
Okay, thank you.
May I ask a question directly to Mr. Damerow? Mr. Damerow, were you aware of this Chapter 904.02 where it says that if you're not in continuous operation for a year, were you aware of that prior to the meetings you had in October of 2010 when all of this sort of nightmare began? No.
Had no clue about...
So totally unaware of that. So, but during this entire time that you're alleged not to have been operating your business, you were paying a fee, a tax, to the government to keep a junkyard salvage business in operation, right?
That was my issue, I guess. I was dumbfounded, to be honest with you, when all of a sudden, out of the blue, I had a lot of people showing up on the site saying that we were not in compliance, and they were telling, I had 6 men working there. They said they were going to put them in jail if they continued to work on the site. I mean, it was unbelievable. And 4 months went by when we weren't able to even work on that site. We were paying a mortgage, and the 6 guys didn't have a job at that point. And so we're here today to try to rectify that, I hope, and continue.
So you wouldn't have had any reason just to keep a license, and I mean, being unaware that there was any kind of a law, you wouldn't have just paid $50 a month to keep a license in effect just to try to smooth over some law that you were unaware of that just became apparent to you? And
had no clue.
Let me ask you another question. Staff has suggested that, there's a disturbing presumption of guilt in my estimation that they have said because you have not signed this affidavit, because your personal signature does not appear on it, or because you have not provided your income tax returns or something like that, that suggests somehow that, that you're a guilty man. So let me just ask you this. I have a copy of this affidavit right here. Would you be willing to sign that and hand it over to the county attorney right now?
I would.
Can we do that?
Sure. And Mr. Chairman, I appreciate that, but let me just explain why it's not signed. During the time, Roland and I were having meetings, and I was trying to convince Roland we shouldn't go forward because, in my opinion, this case shouldn't be gone forward, and I will explain that later on.
When did you understand that what I've heard the county say is because he hasn't signed this, that somehow suggests that what this person's written here is untrue. And so I think this is just simply cleared up. If he's willing to sign it.
Oh, no, I'm going to let him sign that. No, I'm just telling you why it's not signed. I told him not to sign it because I said, look, I'm dealing with Roland. I'll give him a draft of the affidavit. If this affidavit and this receipts are going to take care of this, we'll formalize it. We'll get it done. After I met with Roland, we found out, no, they want more and more and more.
I'm going to tell you, it would help me tremendously.
No, I want him to sign it.
It would help me tremendously if his personal signature was on it and if he was attesting to this.
Sure.
And this is what he was saying, that would make me feel a lot better.
Since you prepared it, go ahead and sign it. I mean, that's fine.
And does that have to be entered into evidence?
I was simply trying to explain that we held back a little because we thought we were coming to a settlement. It didn't look like we were going to, so.
Melissa?
You can take that right down to her.
Thank you.
Is it valid?
I'm going to hand this to Darcy.
And I'm going to hand to Darcy copies of the FP&O receipts.
Let me ask another question. When the government asks for your tax returns in order to prove something, I mean, is there any reason that he should feel compelled to turn over his tax returns in order to do this?
That's the way I felt. I felt it such an affront.
Because this is the way this is seeming to me at this point. And I'm just going to, this is upsetting to me. Because, I hear things like Chapter 904.02, pre-app conferences. They reviewed his business agreements, aerial photos, laws that nobody would really know about, interagency inspections, notices of violations, things like that. And I'm wondering, why are we sitting here, putting the full force and weight of the county government behind something like this? This is absurd.
I felt like they were trying to put me out of business.
Mr. Damerow, let me handle this.
I mean, this is...
I've got to excuse myself for a second because my chest is bothering me.
Okay.
When I see a bumper sticker that says, I love my country, but I fear my government, this is what the kind of thing that's freaking me out right now.
Yeah.
I'm upset about this. I'm upset about this. This man has kept his license. He has provided receipts. He has signed an affidavit. We've got, the county spending time and money and taking aerial photographs and all kinds of, this is like Big Brother.
Yeah, Mr. Zimmerman, all I can tell you is, and I have all the respect in the world for the staff, and you're preempting my closing argument. My closing argument is I don't know why we're here, but the only thing I could come up with is they didn't want to make the call, they wanted you to make the call. I mean, that's all I could come up with.
This man has had to hire attorneys and everything else to keep running a business that's been there for 30 years?
Yes, sir. I'm finished with evidence. I just want to
this is disturbing to me. This is disturbing to me.
I've got a question for Mr. I don't know if you can answer it or not, Bruce. We may have to have Mr. Damerow come back. When he bought this property in 2005, I assume that he was aware that it was under a non-conforming use. I mean, a title search would.
I don't know. I can tell you that nobody called him and said, "Hey, we think you haven't been in business for 11 months. You better do something, or we're going to yank your license." Nobody gave him that kind of notice, which I think should be a prerequisite. I just, for the record, so we're clear, I'm going to hand to Darcy the FP&L records I mentioned, the commercial lease, and the photographs, so that they're in your packet, in your record. Thank you.
Okay. Mr. Brognanis?
I just want to agree with Mr. Zimmerman here that it seems to me that even if this gentleman sold one set of rims during the course of this year, that would constitute doing business. And I don't think that the county has been able to prove that this gentleman has not done business. Not in my opinion, at least. I mean, that's just how I feel.
Sir, I noticed you came in late. Did you take an oath?
No, I didn't.
Okay. Darcy, would you administer that, please?
You raised your right hand. Do you swear or affirm that any testimony you're about to give is the truth and nothing but the truth?
Yes, ma'am. First of all,
your name,
Shannon Cook.
And your address, Mr. Cook?
I live in Sebastian. 868 Schumann Drive.
868 Schumann?
Yeah.
Thank you.
First of all, the photos that you seen at the end were taken within the last month. Every one of them you seen was taken within the last month. Okay. Second of all, the wattage on the electric bill, I want to see what the wattage use is. I'm going to say 0, because that's what it is. Now, I've got the pleasure of being next to cesspool for the last 5 years. I mean, this place is a disaster. It's a code enforcement violation from one end to the other, and I've asked for it to be cleaned up. I've dealt with this mess for years, and I've been on the phone with the gentleman who owns the place, asked him to clean it up. I've dealt with this. I'm not the one that's complaining, but I'm here to testify to say I'm next to a cesspool. There is garbage that is 15 foot high, hundreds of feet long, $1 million worth of scrap. I mean, not scrap, but junk. Not junk, metal, but garbage, household garbage, tires, junk. Okay, I've got one simple set of questions here that'll solve all. And, there's more than 1 year here that between the questions. You're saying 1 12-month period. There's a question of 05 to 06, 06 to 07, 07 to 09. All of them years got to be accounted for. 1 year of lapse. Okay. Now, I am the gentleman that bought the cars on the property when I was told that they were closing the scrapyard and making a warehouse industry park. I'm the one that bought the cars. I got all the titles. I got proof. I'm the one that bought the cars. And when they shut the yard down and closed the doors and haven't been open since. Okay. List of items required by the state of Florida to operate an auto dealer salvage license. I will know. Trust me. I've been enforced by you guys to abide by them. Okay. I've been forced. I've been walked into. I've been threatened jail time. Everything to abide by these rules. Okay. One of them. A second-hand dealer's license or secondary metal recycling license required by the state of Florida to be in business as an auto salvage dealer. It is required by the state of Florida. You cannot open the door. I don't care if you have an occupational license, what you have, and call a salvage yard if you do not carry these licenses. You can't do it. Okay. Number 2.
I'm going to interrupt real quick. Does the staff have any evidence that he has that license or does not have that license?
No, I was asking that question directly on the road, but we don't have that. We don't have that information in hand, one way or the other.
Thank you.
Okay. These, state required in order to have a salvage yard. without question, must have stormwater permits showing where your discharge and where your stormwater is going, required by the state of Florida in order to be in business as a salvage yard. Doesn't have them.
Whoa. Objection. The gentleman doesn't know whether he has a stormwater permit or not. What is the source of your information that he has no stormwater permit?
Because I've looked it up. And
No.
I've seen that you applied for one.
Do you have a record?
I've seen that you applied for one, but you haven't got one. And
Well, I
you
don't know
haven't
what you
had
looked up,
one
but I didn't
since...
apply for one. I've only represented this gentleman for this hearing. right
It's been applied for, but it's not been established. And it's
Okay.
supposed to have been in effect for the last 10 years. But we'll let that go there. But one more thing. The receipts and sales tickets you have as tickets, okay? You have the receipts. Every sale in the state of Florida is required a sales tax on a used part. That should have a cross-reference record with the sales tax through the state of Florida, item transaction number, down to that tax number. It should be able to show that they paid tax on that sale. Okay? Very simple way to track your records.
Again, question for staff. Do we have any evidence that the appellant filed taxes on these transactions?
State law, you have to.
No, the appellant did not provide that information.
Okay.
Let me ask a question. Let's say let's assume that he didn't pay sales tax on the transaction. Does that mean that he wasn't operating this as a junkyard?
If he's not licensed, it is.
Let's say he didn't have a license. Let's say he didn't have one of the numerous licenses he was meant to have. Does that mean, under the county code as it was described to us in the definition, that he was not operating it as a junkyard, or does it mean he was operating as a...
I certainly hope so, because I was threatened with jail time.
Time out here. It would go to proof as to whether he was operating legally, which would go toward whether it was a legitimate business.
Okay.
Okay.
Wait, I'm sorry. Would you repeat? I couldn't quite understand what you said. No, away from the mic. Thanks.
Whether or not he was paying taxes in compliance with the law. And again, I have no idea whether he was or he wasn't, and what the state of the law is in regard to that. But if, in fact, he was required to pay taxes and he wasn't paying taxes, then he wasn't in compliance with the law and he wasn't operating a legitimate business. It would go
So
to
if you're a doctor and you don't pay your federal taxes, you're not operating legitimately as a doctor?
I'm not trying to argue with anybody here. I'm telling you how you might want to look at evaluating the evidence. I'm not representing anybody here but you guys.
Licenses. Not even taxes, but licenses. You have required me, as a board, as this county has required me to abide by something. Licenses. It goes to saying it was a legitimate business. If it's not licensed, it's not legitimate.
So,
Okay.
if you had a license, if you did not have a license, you would have been shut down.
Absolutely. I got threatened.
So then I would assume Mr. Damrow had a license because he was not shut down.
I don't know, but it doesn't matter. The state isn't coming after Mr. Damrow for anything. You're coming after him for not operating a junkyard. If he didn't pay his sales tax, that's a state issue.
We're not talking sales tax, we're talking licensing.
And whether he paid sales tax or not doesn't determine whether or not he's operating a legitimate business. It determines whether or not he paid sales tax. It has nothing to do.
It goes to the competent and substantialness of the evidence and what staff is presenting and whether you can rebut whatever staff has
Staff didn't present that. This gentleman presented it as hearsay.
Okay, but
let me finish. And staff never asked for that. Staff never asked for any of that.
State
And had they asked for that,
required
we'd have-
licensing.
Excuse me. Staff never asked for any of that, and I resent that we're being held to a standard when it's the staff's burden to prove something, not our burden to prove the negative.
Okay. All right. Continue, Mr. Cook.
Okay. Like I said, it's a state-required license in order to have a salvage yard. So it's not, you can't have a salvage yard. And, there's an issue right now in Roseland where a gentleman just got shut down because he was on IG and he had an occupational license. They shut him down. They just did it. Okay. He's going to have a problem with that gentleman. The phone number. What's the phone number? If you're being in business, you must have a phone number somewhere. Records of waste oil removal and containment. State required to have it. Where's the waste oil, the contaminant oils, everything that you used on a salvage yard bin? Where's it gone? It's state required to have record of it. Okay. Business, of course, that's none of my business. I won't even say taxes. That's not my business. But titles. Anytime you do anything to do with a salvage yard, titles. Any title you receive and get, you must take to the state of Florida and junk. You must do it. It's state required. See some records for that over the last few years. No, ma'am, not without the other license. You cannot. You must have a state-required dealer's license then, different license. Okay. Now again, I come back to the electric bill. $10, $8, $9, that's administrative use. That's not wattage, I promise you. Wattage is going to show 0. The pictures that show the items in the side of the field, I bought the vehicles. I'm the one that took them off site. What was left was what he was supposed to clean up, which was 2 fiberglass boats and 2 decapitated motorhomes in that corner. Wouldn't take them because they weren't worth scrap. I bought the scrap metal off the yard when they shut the yard down. So them items were left there when I bought the scrap metals, which he got paid for to remove them in 2005. Now, I mean, in my eyes, it's pretty simple. You know, it's a matter of saying you were in business. You know, you got a list of required items. You got your secondhand metal recycling license. You've got your stormwater permits. You got your sales transactions that you can cross-reference with sales tax records that they've already provided. They should be able to provide the extra. If you sold something, you should have record of it. You should have sent, say, 7% of it. Okay. And they made their attempt at the electric bills. You know, it may seem like I'm being a real jerk here, and I'm going against something, but let me tell you what. I've bought this yard. I've worked my butt off out in this county to make it look like it does, and I've spent a lot of money and I've done a lot of work, and I've repetitively tried to get this place over here. We've been under fire, and the board knows. Junkyards down this road have been under fire. We have now recently went through a zoning attempt change because the county is all over us. They're on us, DEP's on us, EPA, code enforcement, you name it, the agency's on us. And we're kept to a high level. We're kept to a very high level. And I think the community's appreciating this. I think you guys are doing your job doing it. You know, you've pushed the issue. You've pushed and you've pushed to the point to where damn near ruining us. Not no offense to you, but damn near putting us in a subject where we got to spend a lot of money to come up and make everything the way it's supposed to be. Well, let me tell you what, next door has not been. It's been a cesspool. I've asked for it to be cleaned up. I've even offered to clean it up if the dump fees were paid so it stopped coming out of my property. I mean, there's 100,000 tires on the property. Without exaggeration, they're as big as this building. You know, there's garbage from one end of the property to the other. And I've watched many items be removed and put underground, buried, hidden. Now, to use the property as something else, to me, for the community, is going to be better, not even as a competitor. I mean, because I'm representing the scrapyard. I'm not an auto salvage yard. But I've owned the property next to them and had to deal with this stuff. And, you know, I think I've presented my case here. If you just go by state requirements, not county, not anything but state requirements shown in order to be a salvage yard, you must have these requirements.
Mr. Cook, what we're addressing tonight is whether or not this man has been in business continuously without a year lapse. And I understand your position, and I understand that you have other complaints. That is what we're addressing tonight, just that one statement.
Okay.
Can you say that this man was closed down for a certain period of time? Can you give us any kind of proof that he was out of business?
Well, for one is, you know, the transactions must be traced over. You're going to find out.
No, that shows he actually has had transaction and
Right.
has been in business.
Well, I mean, the licensing, you know, you must be, now, if every one of us down the road, and they're sitting in here, the other yards, if every one of us have been attacked for doing business, okay, do this, do that, make it this way, do that, okay, and we all have to listen, but this yard don't, because they're not in business.
Madam Chair.
They're not doing business.
His testimony is evidence in itself. So if he's testifying to his personal knowledge, that can be considered evidence. You will give it weight as it should be accorded, but it can be considered.
What I'm looking for is a specific statement that says he was not operating between this.
The tire tracks you see in the pictures was from them when the code enforcement got a hold of them. And they went out there and pushed stuff in different piles and it looked a little different. And where it says made somewhat of an attempt on your records, They went out there front end loader, made piles.
How long were those cars there? I'm sorry.
The cars, I took the cars out in 2005. There was no other cars. The pictures you seen of the cars were in the last month that they've moved in.
Okay, all right. I thought you said the pictures were within the last month.
No.
The pictures are the cars were moved in there within the last month.
Right.
Okay, I'm sorry.
The
Dennis.
pictures of all the cars were back in 2005. There hasn't been anything else going on in that place.
But what you're saying on the aerials where in December 2008 and in September 2007 where it appears there are cars, that's not correct? That aerial photo? If you want to pull back up those aerials, specifically dating September 2007, it's pretty clear to me that there at least a potential there for a yellow-looking school bus.
The school bus has always been there. It was there. I left it there. Because it was full of garbage. I did not purchase it.
Okay.
Mr. Cook, as I understand what we're supposed to do tonight, does it determine legality, whether the man has permits or licenses or what his electric bill reveals? We're here to say, to judge by the evidence presented, has there been a 1-year period where no auto salvage sales took place? That's all. I agree with you about illegal sales and all that, but we're not here to discuss that. We're here to look at 1-year period.
I've been there for 5 years and haven't seen the doors open.
How? 5 years?
5 years. Since 2005, I haven't seen the doors open. I mean, they've been shut down, they've been collapsed. Code enforcement's made, I know, a bunch of attempts to get a hold of them. They haven't even, look, I even got it for a note, that they weren't even able to contact somebody.
When you bought the thing, that was a sale in that year, when you bought all those cars. So that year he had sales.
When I was told by him that he was shutting the business down and turning it into a warehouse operation, industrial park.
And that was 2005.
That's when I bought the cars. I mean,
to your knowledge, there has been
nothing.
No activity since 2005.
Nothing except for a big mess. And we're taking heat for it. All the other yards down the road are taking heat because they look from the county park and see this massive mess. And it comes down, I get the hell kicked out of me to do everything in his yard and nothing to this guy. Just us, the guys that are doing business.
And when did you say you bought all those vehicles? In 2005?
Right when you seen them disappear.
Well, actually, AAA Auto Recycling LLC did submit or did file with the state of Florida a dissolution that was approved by the LLC December 30th of 2005, saying that all members elected to close operations.
I know. They chose to close down in 2005. I mean,
and they filed that with the state.
Thank you.
Mr. Barquette? Mr. Cook, Mr. Barquette has does he have the right to do that? Yes. Make it a pleasant cross-examination.
Mr. Cook, where were you on March 8th of 2008?
I'm sorry, that's going to be pretty difficult to answer.
That's my point. On March 8th of 2008, do you know, for example, that a vehicle wasn't distributed to that site, torn down, stripped, and sold for parts?
Not that I've ever seen.
Yeah, but were you there? Were you in present?
Yeah.
Oh, so a minute ago you didn't know where you were.
Well, you asked me if I was on site. If I was on site, I was on the job site. I mean, I can show a record of that.
Let me try again. Where were you on March 8th of 2008?
I was at my job.
And
if it was on a weekday, I was on my job. If it was on a business day.
I'm just asking you if you know for a fact that no vehicle was delivered to that site, because we have a receipt showing that it was, and that it was stripped for parts.
Was it done with license?
Do you know for a fact that it didn't happen? And how? How do you remember that date and that specific event?
I can't tell you that because it's a ridiculous question.
Well, no. Well, okay. How about April 3rd, 2008? Was there a 2000 Chevy with the 350 CID engine?
We're talking 6 years here. We're not talking 1 year. We're talking 6 years.
Actually,
and if you made a transaction, there should be a sales tax transaction of it. There should be a transaction of everything. You should have record of this.
You want me to go through all these dates? How about April 20th of 2000?
I can make dates up too. I can put paper together too.
Do you know whether a Honda was delivered to the site and stripped for processing on April 20th, 2008? Yes or no? It's a yes or no question.
I don't know this. I mean, I can't go back and ask these questions. But since I'm back up here, this gentleman is supposed to have the lease, has had a lease in 2 other places in town I can show you the whole time.
Mr.
He's
Cook.
been in business and has had problems with it, so I can prove that the lease wasn't being honored during his
Can I ask
there.
just one quick question?
Go ahead.
I am very well convinced of your frustration, particularly in regards to what you've described as sort of the heat coming down and the higher level of scrutiny that you and your fellow businesses are receiving in this corridor, and so on and so forth. And it sounds to me like part of your frustration has to do with perhaps a perception that there's unequal treatment or unequal response to the pressure that's coming between you and the other one. And I'm wondering if your legitimate problems with this neighboring property are not more correctly code enforcement issues, that if if it were brought up I'm asking a question. I'm asking a question because I heard what you said. And so I'm wondering if it was brought, if this property was brought up to, was operated with the same level of professionalism that yours and others were, or the same level of code compliance than yours and others would that be satisfactory? Would that be a satisfactory outcome?
Here's the thing, though. The question is here.
Well, I really want to know the answer to that question. If it were brought up to, if the same scrutiny and the same
You
code
can't go in the
compliance-
past, though.
Well, I'm from here forward.
From here forward?
Would that
That's
be a
not the question from
satisfactory
here, though,
result
sir.
for you?
That's not the question here. The question is, has he been in business?
Okay.
And in order to tell me that he's been in business is to tell me he's been licensed. And in order to be in business, you must be licensed. You must be licensed.
Okay, Mr. Damaro. We'd like to satisfy the situation, the question
Mr.
about this man's
Damaro, the
business.
reason we postponed the hearing from last time is Mr. Damaro had a heart attack. And so tonight, when Sam was getting all worked up, Mr. Damaro was getting all worked up, so he's out in the lobby panting, and he's not going to come back in. I'm not going to subject him to any more.
Okay, does it make a difference whether or not this man had the secondhand dealer's license? Does that have any basis whatsoever on what we're talking about tonight?
If the county had asked us for it, and I would have asked Mr. Damaro, it might. And I agree that Melissa might have a good point that it might determine whether he was operating legally. But it was not asked ever before tonight, and I'm not going to bring Mr. Damaro in to do that.
It can be looked up on the computer. All you got to do is go on .gov, and it can be looked up.
Excuse me. I didn't interrupt you. I just cross-examined you. I'm not going to ask Mr. Damaro to come back in to do that. But again, it was never asked for before. And that's not, and if he wasn't, then the state can come after Mr. Damaro, but that's not the issue here. The issue is, did he have any transactions during the 1 year period, during any continuous?
That's not the question. The
What
question
I'm
is, was he in business? The question is, was he in business, not whether he did transactions. The question says, was he in business?
I think our attorney has, wait a minute,
Yeah.
okay? I think our attorney has advised us that if he was not in business legally, then we do not consider him as having been in business. Is that what I heard?
But we haven't even established that this license
I'm
is
sorry,
required.
I asked
We haven't
Melissa
even
that.
established that this license is required.
I
We
asked
just got it from
Melissa.
this layman that's telling us that.
Bruce, I asked Melissa.
That's correct. If the business was not in business legally, it cannot be considered a business. It has to conform with the laws of the state of Florida and the county.
Okay,
So
staff.
illegal business doesn't count.
An illegal business? No.
Right.
Okay, staff, do we have any proof that this man had a secondhand dealer's license? Or that he even required a secondhand dealer's
I
license?
have proof. I have a printout from the State Department of Revenue site that says, I'll read exactly what it says, I'll put it on the overhead. It says, salvage, scrap metal, and recycling center businesses must register as secondary metal recyclers and comply with record keeping and holding period requirements. That's what it says. As far as if he has the permit or not, we do not know that. And that is a question that, if Mr. Damaro was here under oath, I would ask him that question.
Okay, then the only thing I can suggest is that we postpone this meeting until Mr. Damaro can provide that proof.
Would you like a motion for that?
Yes. Oh, wait, well, we're still in a public hearing.
Okay. Yeah, right.
I'm sure that a lot of the other public wants to be heard as well, so I'll step down.
Thank you, Mr. Cook.
I have a question from Melissa. Doesn't the staff carry the burden?
Yes, the way that this works is that the commission has to take staff's case in chief and evaluate it and decide whether they've made a preponderance of their case. If you decide that based on the evidence presented to you, they've made their case, then you can look at Mr. Dameron's case to see whether he's rebutted their case. That sounds very technical, but I think basically, did the county make their case? If you think the county made their case by preponderance, then did Bruce and Mr. Dameron put on a case to counteract what the county did? If you feel you don't have enough evidence to make that determination, then I think that you might want to consider a continuance. And Bruce can speak to whether his client is amenable to that.
I think Melissa stated correct.
We can't hear you, Bruce.
I think Melissa stated correctly. The burden is on the county if whether they established their case in the first place, and I assert that they didn't. But if you feel that they did, then you have to determine whether we rebutted their case successfully. And the county didn't put on any evidence that he doesn't have a license. The county didn't even ask the question when he was up here. So I don't think there's an issue. But
Bruce,
and plus, I'm not even sure that a license is required. That hasn't even been established. We don't, we've got a few.
I think that has been established.
No, we've got Roland reading from an ordinance, but we don't know the context of that statute. We don't know the whole context of the statute. I mean, it's possible. I don't know the answer to the question, but again, that was part of the county's burden, and they didn't put it forward.
It should be a very simple question to ask Mr. Dameron.
Well, my intent was to ask Mr. Dameron a few questions, but he left before we had that opportunity.
So we haven't had an opportunity to prove our case, Bruce. I mean, the county hasn't had their opportunity to prove their case. We have a sidebar going. Okay, is there anybody else that would like to address the commission on this? Sir.
You're welcome.
Yeah. I'm the one that was I understand the frustration about the cleanup.
May I have your name and address, sir?
My name is James Staggs, S-T-A-G-G-S. I'm general manager for Mr. Dameron. I got hurt real bad in a car wreck. I shattered my ankle. I had 3 fingers cut off. And I repaired a loader in a cast that was there that's never been moved in 5 years I know of. Matter of fact, we had to have the loader fixed. The loader's still there. I'm talking about never been moved off of the property. It's on the property, never been took off the property.
The loader.
There's no school bus there, and the trailers belong to me. I've got the titles to them. I can produce the titles.
Are you saying that Mr. Dameron was in business or was not in business?
He was in business. What he had me doing, I got hurt, so I wasn't able to do a whole lot. I was only maybe able to make 2 or 3 sales for him a month. Not every day, everything, but 2 or 3 sales a month, maybe 3, maybe 4, because I was very, very hurt. I had a shattered ankle. Yes, I have other leases. Me and my family hold 4 business licenses in Inner River County. Automotive repair by James Staggs Ministries. We own the Silver Clipper Barber Shop, me and my brother. I'm sure you all know that. I own James Staggs Counseling Center. I own James Staggs Ministries.
Mr. Staggs, do you have a second-hand dealer's license?
We don't. It's not required unless you're selling vehicles.
Okay. What
Unless you're
licensing
actually
is
selling cars on a car lot to an individual, it's not required by this law. That you can sell parts to anybody, but you can't not sell.
All right, Mr. Staggs, so you're saying that Mr. Dameron was in business as a junk or salvage yard since 2005?
Yes, I met him in 2005. I was in a car wreck.
Thank you. Thank you.
Excuse me. There's one other thing I would like to say. I was in the process of cleaning the place up. We were going to destroy the trailer that was there that was damaged during the hurricane. They come in, they threatened to arrest me and my guys and told them they would put us off the property. Code enforcement did. And I was arrested many years ago for a trailer on the side of the road, and I was found not guilty. They arrested me, so I was scared, and so was my guys. You know,
when was this?
Many years ago, was paid to I've owned a business for 30 years in this town. On Oslo Road, there was a trailer that broke down, and the people refused to pay me to repair the axles that broke, It cost me $450 to get it removed off of the highway onto the side of the road, and the people that owned it, which was a church called...
Okay, that has nothing to do with this, Mr.
I'm just
Staggs.
letting you know,
Please.
my guys
All right,
were
thank you,
scared.
Mr. Staggs. We appreciate, the lady in the back has had her hand raised for a long time.
And I do want to make note that as members of the audience come forth, if they're testifying from their personal knowledge, you can consider that as evidence. If they're just giving their opinion, that has to be given that way.
Good evening. My name is Annie Smith Pryor. My address is 4655 43rd Court. I'm right behind the junkyard. And I was listening to you, and I was saying to myself, but he doesn't live there. I've lived there almost 34 years. It's my parents' home. And I can't tell you the timeline. I've been listening to everything. I can't tell you the timeline, but I know it's quiet. I know we don't hear all of that boom and crashing and all of that. A lot of times we wake up early in the morning hearing a loud noises. I have my two daughters, and sometimes when they were younger, praise God, and I'm sorry, praise God and everything. Tonight I'm supposed to be at church. I'm usually at church, but when I found out we were having this meeting, I said I wanted to go to tell you, to express. I haven't made a complaint, but I wanted to many times. It's really loud. It's an eyesore. And just, I go out my backyard and cross the ditch. You can see all these cars and all of this load, a whole lot of stuff. And it's an eyesore. And one time I was trying to get a refinance. Well, I did get a refinance, but an appraiser told me this junkyard brings down the value of your home. And sometimes we go walking, and the south part of the park, where the ball courts are, the baseball courts, I've gone down there, and I say, this is a shame. All these cars and whatever it is piled up here. Children are playing here. People are going back and forth to the park. And it's embarrassing. It's been embarrassing to me being in my home to see all of this junk. And not only that, rodents, animals come from over there, snakes and a whole lot of stuff.
I'm going to interrupt you.
Yes,
do you have any proof, or are you giving testimony that this business was shut down for more than a year with no business operating on that property?
No, I don't have proof. I just know it's been quiet over there.
Yeah, he did say that he had stopped doing the crushing.
Okay, that's why I just wanted you to know. It's embarrassing. If you live there, you'll feel how we feel.
I'm sure. Thank you.
Ma'am. Approximately when did you call those complaints in about the noise, et cetera?
Oh, no, sir. I said I never complained, but I wanted to.
I thought you said you complained.
No, sir. I wanted to, but I never did.
All right, thank you, Mrs. Pryor. There was another gentleman in the back here. Okay, all right, sir.
My name is Quentin Williams.
I'm sorry, I didn't get that.
My name is Quentin Williams.
Quentin?
My address is 4675 43rd Court. I also live right behind the junkyard, and I can testify that it's within a year I haven't seen anything. And just like she was saying, it's ridiculous for all of the trash and all it's a mess. You can't even walk outside without getting bit by a mosquito. I mean, you can't enjoy your yard outside behind that facility. I haven't seen anything or anyone or anything behind there. All I see is trees and grass.
Can you swear that there have been no cars, no vehicles, no business on that property for a year?
From what I've seen, yes, I can swear that it's been nothing but trash.
No vehicles were in that yard?
Coming or going?
None that I have seen. And I've lived there for 20 years of my life. So I just decided I'd say that.
Okay. Thank you, Mr. Williams. Okay. Mr. Burkett.
I just want to point out this piece of paper that Roland was reading from is not a statute or an ordinance or a law or anything. It's just an article. So it has no legal probative value whatsoever.
You're talking about...
Mr. Cook?
No.
It's absolutely a statute. It's a state statute. It does have a statute number. It's absolutely a state statute.
Mr. Du Bois would like to say.
Yes, Bruce just referred to the piece of paper. I'll tell you exactly where the paper came from. I got it from the Department of Revenue website on their information from their website. on the secondhand dealer's requirements.
Okay. Mr. Cook,
So-
I have a question for you, too.
Yes, ma'am.
You said, I understand that the secondhand dealer's license is required if you're selling cars to people, or is
No,
it
ma'am.
required if you're just selling junk cars to people,
Okay,
too?
here's how it works. If what
Gentlemen.
gentleman, Mr. Stagg said was absolutely wrong. In order to operate any auto salvage yard, just like it says in the ordinance, you must carry a secondhand good dealer's license, secondary metal recycling license. Okay, in order to sell cars, you must carry a state-required dealer's license. Absolutely, totally different license. As a matter of fact, you're not allowed to sell cars on heavy industrial property. You're only allowed to sell cars on light industrial property. So his property actually would work for a car lot, but would not work for a salvage yard in the LDRs.
Okay, I have a question. There's a secondhand dealer's license, and you mentioned another
A secondary
license.
metal recycling license.
Secondary metal recycling license.
He would be totally required to carry the secondhand good dealer's license as an auto salvage dealer. And like I said, there's several other things too. The stormwater permit's another one. You can't
I'm not
do
going to
this
go with the stormwater permit issue, but I am concerned about proving that this man had a legitimate business going on for the continuous period of time. And I'm still trying to get from you I'm hearing secondhand dealer's license, I'm hearing secondhand metals license, I'm hearing secondhand goods license. What am I talking?
If Bruce can give me back that piece of paper again, I'll put it on the overhead.
Thank you.
Haven't presented any evidence.
Can I come up and show you something real quick?
Bruce doesn't know.
It has to enter it into evidence, doesn't it?
What is that, sir?
Can I show you something real quick? Oh.
Let me first.
We may need to get a copy of that if we're going to consider it. Must register the secondary metals recycler and comply with record-keeping and holding period requirements. Secondary metals recycler.
Looks like the statute 538 there.
And what I'm about ready to show you here is also a state requirement that's posted on your wall in place of business.
The question I have, I think this is a legitimate, I do think this is a legitimate line of inquiry, but the question I have is, let's turn it around the other way, and let's say that he had obviously every day been selling junk, salvage, everything there, been selling engines out. All these neighbors could see that that was happening every day for years and years and years. And let's say he didn't have this license. Would that therefore mean that he had not operated as a business, as a junkyard for a year? I think so.
Back a few years ago, it would have. But, like I said, from the county itself, that come down on us like a cinch knot. They come down on us like a cinch knot.
In terms for non-conforming use, it does make a difference, because you have to be a legal business in order to claim your non-conforming use.
Is that somewhere in that code part that you brought out for us where it talked about where it needed to operate?
It's in Florida case law, Florida common law. I didn't put it in my memo to you because I didn't know it was going to be an issue. But it's one of the foundations of Florida non-conforming use law. You have to have a valid operating business in order to claim the non-conforming use. If you're operating without permits, for instance, if you were a restaurant and you didn't get the permits necessary but you were operating without them, then you can be denied that non-conforming status.
Okay, so it appears...
But I have to say, I don't know whether or not I'm trying to look on my iPad right now in the statutes to see whether I have not researched whether they have a license required. So I'm not saying they do or they don't. I'm just saying if they did and they didn't get it, then they are not considered a legitimate business in order to claim a non-conforming use. But I don't think that's been determined whether they had to have one.
But in this case, that's the staff's burden to...
Every other yard in the road.
I have a commissioner that wants to ask a question of our attorney. Go ahead, Jens.
As much as I hate the thought of this coming back, just exploring the legalities of this, for what the staff has presented, can we table this to ask for more evidence? Or do we just have to go on what is before us, that we don't know if this is a legitimate business. If it's not a legitimate business, then it does concern us, but we don't know that.
You can move for this matter to be continued. I don't believe that the appellant is going to be prejudiced. Bruce, correct me if I'm wrong. So it's up to the commission. If you want to do that, you can do that.
We have to wait till the public hearing closes to do that.
Yeah.
It seems that this is the focus of the issue.
Yes, it does.
It's right here.
Yep.
And it seems that we've gone as far as we can go.
And I realize that it is staff's responsibility to prove that they are right and that your client is wrong. But I think there's this one piece of evidence that you need to provide us that says, yes, he had a legitimate business going on.
I think there's two things that need to be determined. One, I would like, what you say makes sense to me. I would like a definitive opinion about whether or not that evidence is a critical piece of evidence or not in terms of us making our determination. If you can advise us that that is in fact the case, instead of, kind of thinking it is, but, look it up and know, and then we can see whether that, if yes, that is a definitive piece of evidence, then let's see if the county can provide it as the preponderance of evidence. I mean, right?
Right.
Yes. All right, Bruce, I make a statement. I think we're going to close the public hearing for a motion.
Before you do that,
Okay. You want to say something?
Yeah, I do. The county's issued this man an occupational license to operate a junkyard. If a state license was required and the county didn't ask for one, it's not up to this board to determine that he's operating illegally because he doesn't have a state license. If the state wants to go after him for not having such a license, that's fine, but he's not operating illegally according to county regulations. The county keeps continuously taking his money and issuing an occupational license for him to do business, which he has been doing on this site. If he's in violation of some state regulation, that doesn't make him operating illegally.
Mr. Burkett, I'm hearing from our attorney that it does make a
No,
difference.
you haven't heard that from your attorney. What you've heard from your attorney, that's something you can take under consideration. The other thing is, the county has had a lot of time to prepare its case. It never once asked us for this. The only thing it asked us for was the occupational license, which we provided. I would like a decision tonight. And if they don't like it, they can take it up to the Board of County Commissioners.
I can understand your position. Thank you. Mr. Wolford?
Freddie Wolford, 4590 57th Avenue. I missed choir rehearsal tonight to be here. As the young lady says, she normally would be in church, I would be in choir rehearsal. But my Progressive Civic League of Gifford, Florida, Inc., which I am a part of, some of them could not make it. I told them I would come and at least listen to the pros and cons about what's going on with as far as the junkyard being open 1 year or not. This is not a new item on the agenda of the Progressive Civic League of Gifford. We've been meeting with staff now, I'm going to say over 2 years. So this is not a knee-jerk reaction that you see tonight. We're simply asking that all conformities be across the board as far as 45th Street. That's our middle of our community. And it's been zoned like that since 1951. Why wouldn't anybody say anything about that back during that time? Man, for a black man to come down here in 1951 and say something to the white people about what goes on in Gifford, you're crazy. So we are saying something now. We are saying this is our community. We live there. If you're going to shut down different businesses down the street of 45th Street who sell fish sandwiches, and that's what they're doing now, you have to have a permit to be a legitimate seller of foods, and you're not going to shut down a business, whether you've been operating 20 years illegally, and say, well, they did junkyard selling all that time, they're legitimate. That's crazy. If you don't stop my food, stop the contamination too. And the gentleman who spoke a few minutes ago, Mr. Cook, it's not pressure, it's protocol that we're asking for. Get your business to the level of decency that it doesn't affect the neighbor who stays 10 feet away from you. That's all we are. We're not putting pressure. We're asking for protocol to be established and that every business along that corridor do so. Now, if the gentleman who is here, I'm not here pro or con, but if he's not living up to the protocol that has been established by your ordinances, then he's operating illegal. And we ask that it be rectified and that treat Gifford as any other party in the River County, and we'll appreciate that. Thank you so much.
Mr. Wolford, can I ask you a question?
Mm-hmm.
You speak with great authority on this, and so I ask you honestly: is the interest of the community that this cease to exist as a junkyard, or that it comply with all laws and all code violations are, brought up to?
I'm glad you asked that question.
That's what I want to understand.
You helped me out more. I drive past there, heading to my house on 57th Avenue, right off of 45th Street. So I drive past that constantly. When the hurricane came through there, it tore that place up. And I said, wow, that junkyard really got hit hard. Expecting a quick bounce back, nice fence back up. No, I did not. I saw fence laying over, am I correct? Laying over to the side, no one is doing anything but the one next to it. I saw they had painted it up, fixed it up, the scrap yard. I said, wow, they're back in. Nothing was happening at this particular site. Nothing. Hurricane Francis and Gene came through and put a hurt on it. Yeah. So I watched this. So therefore, to answer your question, is it my wish for it to shut down? No. My wish is that they follow the ordinances that have been established by Indian River County. And one ordinance stipulation said, if by chance that particular site, junkyard in particular, do not open and for business for one solid year, that it will be removed as a junkyard. That's all I'm asking you. Follow you what you have in your books. It has not. I passed there for a year. I've been staying out there now for 7 years. I've seen it. It was not operating as a business. If they did their business, they did it at midnight. If I take an engine to the Indian River Medical Center and I sell it out there, that will make that parking lot of the hospital a junkyard. And that's what's been happening there. They may have brought things from Fort Lauderdale to sell there on that site, but that was not where the legitimate business was taking place. It was pulled there, brought there, taking this all in there. So that was just a bypass. Take it into consideration.
I understand.
Thank you, Mr. Wolford. Mr. Cook, you have to do it at the microphone. It has to be on record. It's not that we can't hear you, it's just that the tape can't.
I just want to let you know, every other yard in the road, whether it's a salvage yard or a scrap metal yard or whatever it is zoned IG. There's not one other non-conforming yard. The rest of them are all zoned properly like they're supposed to be, and have been asked to uphold the laws of that level, let alone the higher levels to be kept up as an IL zoning. That's a privilege. It's not, that was a given privilege. IL zoning. It's not a usage in the LDRs. An IL. It absolutely says not to be used as.
I know it's not. And I must say, you guys have cleaned up your act on that 45th.
We're trying very hard, and we're being held to a high standard, and we want to be.
And it's being noticed. Thank you.
We want to go that route, but we want everybody else to be held the same way.
Thank you, Mr. Cook. Okay, is there anybody else that would like to address the commission on this? Okay, seeing none, I close the public hearing. Gentlemen, your pleasure.
I make a motion to table this until staff provides us with more answers as to whether this was a legal, legitimate business or not.
I second.
Brad, second. Any discussion? All in favor, say aye. Aye. Opposed? Motion carries. Motion was made by Mr. Tripson, seconded by Brad Evans.
Before we leave this, I just want to make a few statements. I'm Bob Keating, Community Development Director. There was some criticism of staff before, and let me tell you, I think we were trying to do our job. We've been working with the Gifford community. You heard from Mr. Wolford for 2 years. There have been a lot of issues up there. We've worked with Mr. Cook and the other business owners there, and we've been trying to resolve a lot of issues with the uses that are there, uses that are allowed, IG, in the community that people are concerned about. We looked at aerial photos, and I think we made the decisions that we thought were appropriate. We've got rules and regulations in place, and you can tell these people who have been working with for 2 years know our rules and regulations. So if you don't like the rules and regulations, let's make a recommendation to change them. If not, we have an obligation to go forward and actually implement and enforce those rules. I want to make a couple of other statements too. There's been some testimony that there have been threats of arrest and things like that. That is not from code enforcement. There are a variety of agencies that have been working up here in this area. We've had the health department. There have been state agencies, DEP, I think EPA there. There have been a lot of violations. There have been water quality concerns. There have been air quality concerns. So there are a lot of environmental concerns, and I think there might have been threats of arrest, but they're from other agencies. So I just wanted to make that point. That's not us that's been going out there and threatening to put people in jail for having a non-conforming use.
Right.
I think those threats are because of real substantial environmental problems that could have a negative health effect on the community. So just wanted to set some records straight there.
Thank you very much for doing that. I'm actually so used to you guys taking the heat, I didn't even think of it. So, thank you.
Take a break.
Okay. Is there anybody here for the comp plan change? The mobile home comp plan change? Okay. Would you mind if we took a 5-minute break? Thank you very much. You probably want one too.
plotting against it now.
Okay, we're going to reconvene the meeting.
No, I will change it here, yes. Okay, it's fine.
All right, next item on the agenda is a comp plan change, and if I can find my agenda. Okay, county initiated a request to amend the comprehensive plan future land use element policy 1.16 to allow up to 25% recreational vehicle use in mobile home park, rental parks of less than 20 acres in size. Mr. Rahani.
Good evening. Sasan Rohani, Chief of Long Range Planning. Hopefully this is easier than the previous item. This is a request for a comprehensive plan amendment. Most of you are familiar with the comprehensive plan and the amendment process. In this case, we are only revising one policy of the plan. But even for one policy, we had to go through the same process for the entire plan. To quickly go over the process, any comprehensive plan amendment involves several steps. First, they submit application to the Community Development Department. First public hearing, we bring it before you here, which is tonight. And if you recommend to the Board of the County Commissioner to transmit that amendment to the State Department of Community Affairs or not to do that. Then we go before the Board of the County Commissioner and they would decide to transmit it or not. If they decide to transmit, then we send it to a State Department of Community Affairs. The state has 60 days, and they come back with the objection, comment, and report, and we reply, and we change if needed. Then we take it to the Board of the County Commissioner for final approval. After that, we send it back to the state for the compliance finding. As far as how many comprehensive plan amendment we could do, there is no limit. However, we cannot amend our comp plan more than twice a year. In Indian River County, we established 2 windows, month of January and month of July. And this particular comprehensive plan amendment we received in January 2011. As a background, in 2007, when there was a boom time and the residential was really very hot, many people they want to convert the mobile home park to a residential. And for us to provide another layer of security for the people that they live in mobile home park, the county actually established a new land use called mobile home rental park. In that land use, we allow only mobile home, and again, if they ever want to convert it, they had to go through the whole process of the land use amendment. In 2008, some of the owners of the mobile home park, they came to the county and they said to make it more financially feasible if the county could allow them to have some RV spaces in the mobile home park. And we prepared the agenda and the staff report, but however, there was some of the residents of the larger mobile home park in the county that they didn't want that one. They didn't want the RVs in the mobile home park. Therefore, the Board of the County Commissioner decided not to transmit that to the state, and as it stands right now, no RVs allowed in the mobile home park unless it's grandfathered in, that we had one park, Tanglewood, that they are grandfathered in and they have some RVs. In 2010, again, some of the owners, they came and to talk to one of the commissioner and to the staff, and again, they asked, maybe if we allow some RVs in mobile home park, maybe it's more financially feasible, and there's not so much pressure on them to change it to some other use. This time, we decided to try it again, but limited to only a small mobile home park of less than 20 acres. And by doing that, we limit them only to these 3 mobile home parks, Tanglewood Village, Hollywood Village, and Ranchland. Also, consistent and attached to these comp plan amendment going to be some LDR changes. With those LDR changes, we make sure that will apply only to existing mobile home park. Also, the big mobile home parks that existing, they cannot subdivide to less than 20 acres and use this provision. But also, we make sure there is no increase in density. We also limit the number of the RVs to 25% of the allowed unit in the mobile home parks. Again, with doing that, there are only 3 mobile home parks in the county that they would fit these criteria. As a matter of fact, again, Stan Bowling and Bob Keating and Commissioner Wheeler, they met with the mobile home owners through 2010, and most of the people, as far as I know, they're all agreeing that this is a good compromise, would provide some additional economic mean for a small mobile home park, but would not affect a larger mobile home park that they don't like these RVs in their backyard. Again, this is policy 1.6 of the future land use element of the comprehensive plan, and yellow part is actually the area that we are adding to this policy. We are adding that they could have up to 25% RVs in the mobile home parks that they are less than 20 acres in size. As you all know, whenever we do the comprehensive plan, we have to make sure, amendment, we have to make sure that it is consistent with the rest of the plan. And specifically, we always look at policy 14.3, and one of these criteria should meet in order for us to proceed. And staff believe that criteria number 2, an oversight happened. Then in 2007, when we created the mobile home rental park, at that point, we could have, done this then, but we somehow didn't think about it, and now this is the time to go ahead and make the changes. With that one, staff recommend that you recommend to the Board of the County Commissioner to approve this amendment for transmitter to the Department of Community Affairs. That's my presentation.
Thank you. Does anybody have any questions of Mr. Rahani? Thank you, Mr. Tripton.
What are you defining as a RV? Does it have to be self-propelled?
Yes, but also another thing that I forgot to mention, one of the criteria that we're looking on the LDR is that the RVs that they're going to be allowed in the mobile home park, they have to be in a mobile home park at least for 30 days.
Right.
They cannot just come overnight and leave and so forth.
Right. I saw that in the material you gave us, but I didn't really see a definition. So a 40-foot fifth wheel trailer that's pulled by a large pickup truck could not be parked there as an RV. It's only like a Winnebago.
No, I don't think so.
No, I think that would also...
Okay, or a 26-foot.
Again, anything that could move in and then move out.
But it doesn't have to move under its own steam.
No.
No,
Okay.
it could be moved by another truck.
For the record, Stan Bowling, Planning Director, we do have a definition of recreational vehicle, and it would allow a pull-behind or a motorized.
Okay. Then the second question is, you have a minimum of 30 days, but do you have a maximum? Is somebody going to be able to pull a Winnebago or a 26-foot Scotty in there and park it there permanently?
That's a good question.
I think they could. See, what the people that they live in mobile home park, they don't like the people to come and go that they don't know. If somebody's there permanently, they really don't have that much problem with it. Because that's become their neighbor and they know the neighbor and so forth. But they don't like the people to come for a few days and go. That's why right now, as it stands, Stan, of course, could tell us for LDR part of it, but I don't think that we are recommending any maximum.
I'm going at this from the position of, say, looking at ranch land, which I see more than the others, even though I know where they are, that they're, they've got a little landscaping and they've got awnings and maybe a little carport. And if you pull a trailer in there, a camping trailer or a recreational trailer, it kind of changes the character of the park. And maybe we need to hear from some of the residents of these parks to see what their take on it is. Maybe I'm worrying about it for
Well, no, actually, following up on your coattails there, aren't there some regulations in the parks that say that the trailers the mobile homes have to have a skirting all around and they have to have tie downs?
Right, that's mobile home, that's requirements for mobile homes, for vehicles that can be moved on and off the site. And again, when you say they're there for 6 months, for instance, they might actually move in and out. They might come in and out or might change, so they're treated as vehicles. The other thing that I did want to mention, and I'm sure you realize this, this will allow a park owner to come, if these changes are made, to come in and apply for the change, and they actually get a very minor site plan approval and show us where the spaces are and so forth. They wouldn't require them to accept RVs. In other words, it'll be a choice of these three parks. It won't automatically happen.
But it won't be a choice of the owners, of the people who have their mobile homes there. It's a choice of the park owner.
That's correct. Unless it's resident-owned park, then that's correct. It would be an owner's choice.
Now, the three parks that are impacted by this look like they average about 17 acres. And at 25% of the slots on a 17-acre park, how many total slots is that?
It kind of varies from park to park. There's a few different densities. It would be on the order of, I'd say, 25 to the high 30s for these parks, if they maximized, 25%.
Any further questions of staff? Okay, this is a public hearing, so I'll open the public hearing. Anybody like to address the commission on this?
Good evening. My name is Gwendolyn Ripp. I reside at Heron Cay, which we call a manufactured home community. I think it's interchangeable with mobile home. The state has never changed its designation as mobile home. I had a chance to meet with Stan and other colleagues from similar parks to review this, and just reflecting on comments that were made, it was my understanding, Stan, that a separate section of the park would need to be designated for RVs in Ranchland, Tanglewood, or Holiday Inn.
What they would do is come in with a site plan and show where the spaces are. I wouldn't say it might be one section, it might be two sections, depending on how many it is and what the layout is, but they would have to designate where those RVs are.
Right. Recognizing that Heron Cay is not affected by this regulation, but I am concerned about its setting somewhat of a precedent which could be built upon in the future. I also recognize that mobile home living is the greatest. I have lived here at Heron Cay longer than I have lived in any other community in my lifetime, and I won't tell you how many years that's been, but it's been over 22 years at Heron Cay. These are double wides, all double wides. Some of these communities may have single wides, and I get concerned when I look across the street from my home. There is now a vacant lot from a home that had to be destroyed, demolished because of its owner's neglect. And if I'm in one of these other parks in that circumstance, I sure don't want an RV parked across the street from me with the possibility of its being moved in or out. And I hope that that is taken into consideration as these applicants proceed with the case. The one other question that I'm not certain is applicable. There's a Florida Mobile Home Act, Florida Statute Chapter 723, which defines what mobile home parks are and what mobile homes are. And I question whether having RVs in a park allows it to be considered a mobile home park. The term mobile home park means a use of land in which lots or spaces are offered for rent or lease for the placement of mobile homes, and in which the primary use of the park is residential. Further, it defines mobile homes as a residential structure designed to be used as a dwelling and not originally sold as a recreational vehicle. I don't know how to wrestle with that and whether it becomes an issue with each individual park as the applicant follows through, and I don't know, Stan, if you've looked into that at all.
I haven't. In terms of the county, it would still be treated as a mobile home park. But you're correct. If it were to have an impact on how they're designated by the state, that would be another question that they would have to look at.
Yeah,
before they applied.
That statute, I happen to be familiar with that statute, and that actually has to do with it has to do with a lot of things, but one of the things it has to do with are the rights of the property owners in a mobile home. It doesn't really have to do with the zoning necessarily as it relates to the county, as Stan said.
No, I'm just strictly referring to definitions as they apply within that bit of legislation, and I don't know where it fits, but I think it needs to be taken into consideration, probably by the park applicants themselves, as they explore with the State Department of Business and Professional Regs. I do have to say that I have appreciated the efforts over the last few years for the redesignation, and I recognize that if this follows through with the county commission, that it will affect these parks only at this time, and that if any of the larger parks wish to pursue this, it means going through the same hurdles from square one all over again, and having to deal with us old folks at the same time. I thank you for any
Thank you
other
very
questions.
much. Is there anyone else? Thank you.
Madam Commissioner, my name is Bill Gorman, and I am the manager at Tanglewood Village Mobile Home Park. I believe I can answer most of the questions that have been asked here today. First off, on Chapter 723, that law went into effect in 1984. That was that was after Tanglewood Village was incorporated. So as such, that's why we're grandfathered in with things like some of the RV lots that we currently have. I can tell you that Tanglewood Village is a resident-owned manufactured housing community. That means that the residents banded together and bought the community, when was that, back in 2001. So it's been about 10 years now. In fact, we'll be having a party pretty soon to celebrate that. Currently, 57 of the residents own the property as shareholders in the property. It is our contention that the problem with the older communities that you're talking about, and those are the smaller ones, is that when hurricanes come through, such as happened with Francis and Jean when they visited us, back 7-8 years ago, it left us with a significant vacancy problem. We've been working diligently with Mr. Bowling and Commissioner Wheeler about getting those problems solved and resolved, because the problem with the older communities is that homes were smaller in that era, and the lots were such that you cannot put a new home on that lot. So what you've done is you've taken a community like Tanglewood, and if we don't do something like this, I would submit to you that you're going to see a very slow and very unsightly death for a community like that, because it's not going to be able to replace homes as they go. That means that the retirees in that community over a period of time are going to slip further and further into disrepair, because they're going to have to put more money into just their homes, and you're going to have fewer and fewer homes as you go down the path. I can assure you that as a resident-owned community, Tanglewood is going to take great steps to make sure that the proper RVs and park models and whatever are brought in, fifth wheels, are brought in to the property, because these are our neighbors. These are the people that we're going to be living with. And I can tell you that we have several instances in the community today because of, on a temporary basis after the hurricanes, we had an arrangement through FEMA and through the county that we could bring in on a temporary basis homes, RVs into the community. And there are several instances, if you were to go through today, where you'd find Class A motor coaches parked next to a 1970 home. The Class A motor coach is probably worth $350,000 and up, and the 1970 home is not worth anywhere near that kind of money. We live in harmony. We're very happy with being together with them, and it's a working relationship. And I can assure you that if somebody were to leave a home, first off, we're very particular about the homes, the RVs that we allow in. We're not going to allow in a home that is, or an RV that is going to bring down the values and bring down what we're trying to do in the community. Any home that is left there, and the people won't stay there for 6 months, but it wouldn't be unusual for them to leave, say, a fifth wheel there. If they did that, we would have some requirements, because after being hit by the hurricanes, we understand that if you don't tie down a home properly, that becomes a missile, and it's dangerous to the person next door. So we would, in fact, tie them down. We'd make sure that they were skirted. We would love to see them landscaped. We would love to see carports or whatever additions are that the county would allow us to do on something like that. So we're full force, 100%, behind the resolution. We certainly thank you for considering it, and I'd be more than happy to answer any questions that anybody would have.
Any questions of Mr. Gorman, gentlemen?
Thank you, Mr. Gorman. With the 25% cap, won't you face a position within the park where some of these older homes are going to have to be replaced?
Yes, and that's a great question. Appreciate you asking that. What would happen is we feel that would give us enough of a buffer zone so that if we had to, the RVs are smaller than the current manufactured house that you're seeing in this day and age. So if you had two side-by-side lots that, let's say they were 40-foot wide, one of them was occupied by an RV, and then that would shrink up. You would need 40 feet. You'd only need maybe 25 feet for that, and that would allow us to give the extra space to the home next door. We could expand and put in a new home. So it would allow us to come in and refurbish and bring in new homes into the community while maintaining the flavor of the community. So we believe it's a win-win for everybody. I know, by the way, we love the RVers who come and spend the winter with us. They bring a lot of money with them, and we find they're the best people for our potluck dinners and everything else. So, and we think they're good citizens for you guys too.
Mr. Gorman, Shady Rest made this change. They were annexed into the city of Sebastian, and they made this change. Have you discussed the situation with the owners at Shady Rest to see if there were any problems associated with this change?
Madam Chairman, I have not, and I'm not familiar with that particular community, so I cannot answer that question.
Okay, thank you. Any questions of Mr. Gorman? Thank you.
We have done this in a number of other communities throughout the state because it's not just an issue. You know, hurricanes they're pretty much indiscriminate. They don't care where they hit. And so we have had the problem, and we have had to deal with it in other locations within manufactured housing community, and we've been very successful with that. So.
Okay, well, thank you.
Thank you.
Is there anyone else who would like to address the commission on this?
I'm Teddy Eaton, Vice President on the board at Tanglewood and a resident of Tanglewood. Tanglewood is a unique park. We're like old Florida, large live oaks hanging with Spanish moss, many palm trees and shell roads. We're a small community of retired, aging residents. For example, my husband is 84, and myself, 82, are one of those aging couples. We are here year-round because of my husband's disability. This will be our last home, and the last home of many other aging people in the park. We want to help do everything we can to ensure that we can stay where we enjoy living. The board continues to seek ways to curb expenses, and the RVers who spend the winter with us in our friendly neighborhood go to the potluck suppers, the pool exercises, bingo, and other events, and they make friends and they come back. Because Tanglewood is a not-for-profit co-op, we have to explore every means to provide security for all our residents. And we do appreciate any help that we can get to move us toward our goal. Thank you.
Thank you, Mrs. Eaton. Is there anyone else who would like to address the commission? Patrick, who?
My name is Brian Ellis. I'm president of the co-op.
I'm sorry, sir. I didn't
Brian
get you.
Ellis.
Ellis, thank you.
I'm president of Tanglewood Village Co-op. After the 2004 hurricanes, with the loss of homes we had, we saw our revenue drop by about 30%. And we were struggling. We discovered, or the RVers discovered us, basically it was an offshoot of the FEMA trailers. They now contribute a third of our revenue. If we didn't have that revenue, we would have to increase our rents to our lot rent people, probably about $50 a month. And for our shareholders, even more. So it's of vital importance to us. In watching commissions, and city commissions, county commissions, by the way, the city commissions are much more fun. Far more entertaining.
We try to be less controversial.
I know. Thank you. I'm a little disappointed about that. The one thing about when topics are brought before commissions and we have the public comment, you have the fors and againsts. And the fors and againsts always have one commonality. They are both going to be directly affected by the action. Here we don't have the commonality. We have the fors, who are going to be directly affected seriously by your actions, and the against, who will not be affected at all. It's that simple. This is so limited, it affects 3 parks, under 20 acres, 3 small parks that are having difficulty. I have no idea about ranch land. It's optional for the parks whether they want to participate in this or not. Our 175 residents obviously are in favor of this, because they do not want the rents and our maintenance fees to go up. Probably 30% of our people are full-time residents. I just wanted to point out that on the question about living full-time, the county does have an ordinance limiting a 6-month stay in an RV. So you're not getting into a situation, have an RV being moved into a park, and this is home. And as we try to explain to many of our residents who don't understand why someone doesn't come back, we've been happy that these things have wheels on them, people travel. We normally figure that we'll lose about 20% of our snowbirds every year, because they come to Vero and they enjoy it, and then they go to the West Coast or whatever. However, we have great success, people coming back and loving it, who spend money.
Thank you very much, Mr. Ellis. We appreciate it. Okay. Close the public hearing? Okay, we'll close the public hearing. My pleasure, gentlemen. I have a motion.
I motion that we accept staff's recommendation that we recommend to the Board of County Commissioners to approve the proposed comprehensive plan text amendment.
I second it.
Okay, motion made by Mr. Zimmerman, second by Mr. Brugnano. Any further discussion? All in favor say aye.
Aye.
Opposed?
Aye. I'm for it. I'm sorry.
Okay.
I'm totally for it.
Okay, it was a unanimous yes, Darcy. Okay. Thank you very much. Next item on the agenda is the A1 Wally Recycling Center. This is Louisa Garcia's request for special exception use approval for a demolition debris facility and for administrative permit use approval for an associated recycling facility located at 63509 9th Street Southwest, zoning classification A1, land use Ag 1. The way we're going to handle this, gentlemen, is we'll have 2 votes on this. One is for the administrative permit, and one will be for the special exception. Mr. McCoy?
Yes.
Thank you.
Thank you, Chairwoman Keyes. John McCoy, Senior Planner, and just want to start off by telling you that my voice is not as good as it should be, so just bear with me, and hopefully we can, or I can get through the presentation. So let me start by telling you this is a special exception use and administrative permit use for the A1 Wally demolition, debris, and recycling. And we haven't done one of these in the county for a long time. As a matter of fact, we haven't done one for over 20 years. So it had several issues that took some time to resolve, and it took a little bit longer in getting here than, say, a normal application would. And I'll try to point out some of those issues as we go through the presentation. First thing I'd like to talk about in the presentation is the process. And it is a request for administrative permit use for the recycling end of it. And to prove that, they need to demonstrate that they meet the specific land use criteria, and they need to demonstrate that it's an appropriate use and it's a compatible use. And the P&Z is to approve with conditions or deny it. And again, that's subject to the board's action on that special exception use. The second process that we're going to go through is the special exception process. And again, the applicant needs to demonstrate that they meet the specific land use criteria, that it is an appropriate compatible use. There are 2 public hearings. This is the first public hearing, and the Planning and Zoning Commission is to make a recommendation to the Board of County Commissioners. And the board is to weigh that recommendation and then approve it with conditions, or deny the proposed use. The proposed use is a recycling center, and really the overall facility has the components of 2 uses. The recycling center, which is really the collection and the sorting of materials such as metals, plastics, cardboard, things like that. And then the demolition components or characteristics are really more the processing of the component, or the pieces that they get. The wood, the mulching, and the concrete crushing would be things that would be characteristics of a demolition debris site. One of the issues that we ran across as we went through this in this review, and one of the things that took us a little while to parse through, and it's not completely hashed out yet, is the solid waste disposal issue and the relationship that the applicant may have with the solid waste. And the county has a solid waste ordinance, and the applicant and the applicant's attorney are working with the county attorney's office on our solid waste to go through those particular issues and see if they need a franchise agreement or any other type of agreement with the solid waste district. If they need to make that determination prior to us cutting them loose for construction, and if they do need an agreement, they'll need that agreement prior to commencing construction on the site, because we don't want to have them commence construction and then find out that they need an agreement and that there's an issue. Just real briefly, I'd like to explain the use as it's been explained to me. Typically what would happen is a construction dumpster, typically a roll-off, would come into the facility, would be, as they call it, tipped or dumped. The contents of that would be sorted through. The items that were deemed to have value would be sorted and kept, either for recycling or for processing and then recycling. The items that were deemed to have no value, and as I understand it, that would be things like drywall and items like that, would then be routed to the landfill. Through the process, we've also, the applicants indicated to us that they will not accept will not accept hazardous waste and will not accept tires. There may be some of that in the waste stream. Again, that would be called out at that initial process, sent to the landfill for proper handling. The next item I'd like to show you is a vicinity map, and really the reason for showing you this is just to show the proximity to the landfill, and it's a use that generally the closer to the landfill, probably the better. So that's the purpose of that slide. The next slide is more of a location map, and it is located on the north side of 9th Street Southwest, and it's just east of 66th Avenue. It's right about 10 acres in size, and it's zoned A1, as is all the property around it. The next slide is an aerial. I'll show you that presently all the property around it is vacant. The site is zoned agricultural, which does allow residential uses up to 1 to 5 acres. I want to point that out. Just a little bit of history. As I understand it, this was originally an irrigation business. It then was converted to a packing house and then back to sort of an agricultural irrigation company, which it is presently, and the request is to change that use to a conditional use or 2 conditional uses. Let me get to the site plan and just kind of walk you through it briefly. The orange area is the building. It's 8,000 square feet. That'll be the portion of the building that's preserved. There's another portion of the building that'll be demolished. The pond at the north end of the site will be filled. The brown area you see is stabilized area, and then all the other shaded area, the dark shaded or the light shaded, is either concrete or asphalt on the site. From a traffic circulation perspective, there'll be a new access point in the center of the site, and that'll be a 2-way access point. It'll be the entry and exit for passenger vehicles as well as the entry for all vehicles. Trucks will be routed through the site and then exit the western driveway, which is an existing driveway now, and that'll be converted to a 1-way exit only. The traffic impact statement and the internal circulation have been reviewed and approved by traffic engineering, and there's no off-site traffic improvements that are required based on the traffic impact statement. As far as stormwater goes, the stormwater will be collected, sent to the stormwater pond, which is on the east side of the site. It's fairly large. It'll be treated and then discharged to a ditch that runs down the east property line, and then discharged to the canal on the south side of Oslo Road through a culvert. I'd like to go over the compatibility items. These are some of the other issues that staff spent some time in dealing with as it went through the review process. For noise, limiting the hours of operation, limiting the hours that processing can occur, and just making sure that they meet the land development regulations. For dust, having a dust control plan that's spelled out there. for fire, the maximum pile height, and we have one other wood recycling entity in the county, and the fire department has derived those standards based on that. Environmental, no material shall be burned or buried on site. Setbacks, they have increased the setbacks on the north and the east sides, and the buffers are provided on all perimeters. That is an 8-foot opaque feature type B buffer. I'll show you a little bit more about that in a second. Other items, they did set aside the right-of-way based on the design, the ultimate right-of-way, for future acquisition for the design. The staff report does outline how they meet the specific land use criteria, both for the recycling and the demolition debris site. And there is a sidewalk required along the Oslo road frontage. They'll need to build that or bond that prior to CO. As far as the buffering goes, type B buffer around the entire facility. The only difference is that on the south and the west side it's 25 feet wide. On the north and the east side it's 30 feet wide. Staff's recommendation is that staff recommends that the Planning and Zoning Commission make the findings as outlined in staff's report for this related to the special exception uses, grant the administrative permit use for the recycling center subject to the board's action, and recommend that the BCC grant special exception approval for the demolition debris facility with the conditions as outlined in those reports. And I just want to summarize those conditions so everybody's aware of them. That they obtain the determination on the solid waste agreement and obtain the agreement if necessary. Construct the buffers and construct the sidewalk or bond it out prior to CO. Limit the hours of operation so they're closed from 5 p.m. to 7 a.m. Limit the processing of materials to weekdays only. No processing on the weekends. Limit the pile height to 25 feet. Maintain a minimum stockpile and aisle width of 25 feet. Prohibit the materials from being burned or buried on site. Use sprinklers or other dust control techniques. And meet the county's noise land development regulations and noise standards. Thank you.
Thank you, Mr. McCoy. Does anybody, gentlemen, any questions of staff?
Are the buffers designed for noise buffering and the visual buffering? Or is it just, are they just visual buffers?
They're primarily visual at that level. It says an 8-foot opaque feature. In this particular instance, it's going to consist of a 4-foot berm and a 4-foot wall, and those will help with noise attenuation. But again, most likely, it's not going to do a great deal for noise attenuation.
Jim?
Yeah, with the wood products recycling, or I guess they're going to be grinding it up for mulch, then are they selling that, or is it going to be going to the landfill or going to Eneos, or?
My understanding is that they would be producing mulch as a usable product for sale on the open market. It could go anywhere,
Okay. And then my second question is, there isn't a sidewalk anywhere else along that property? I mean, along Oslo Road there, and you're going to make these people put in a sidewalk at this time or bond it? I mean, I could see if however many years down the road we widen Oslo and there's a contiguous sidewalk, but at this point in time, it seems to me that's a little bit onerous on a business that's getting started to have to, and maybe the bond isn't that much, maybe that's the way they go, but to put a 300-foot sidewalk in just seems, above and beyond necessity to me.
There are 2 points. First of all, there's a widening project for Oslo Road, but unfortunately it only comes to 58th Avenue, and it'll transition after 58th Avenue, but that'll be in the fairly near future, the next several years. And the sidewalk and bikeway plan does call for the sidewalk to go all the way out, essentially to the interstate, and that is really the bonding out option is really the option we would anticipate them taking.
Thank you. I was clearing my throat, actually.
Thought you were trying to get my attention.
Thank you. So it's ag. So theoretically, land around here could eventually be developed at 1 home per 5 acres.
That is correct.
So is this So it seems like the determination or the recommendation you guys are making generally is that because it's close to the landfill, this isn't, reassure me that this is an appropriate place to have something like this, I guess is what I'm looking for. Does that make sense? I mean, you know, there's appropriate places to have things like this, and there are less appropriate places.
Yes, and I'll flip back on the slides to the aerial.
Yeah, no, I see the green all around it.
Right.
I guess the answer I'm looking for is, yes, Sam, it's appropriate because the landfill is right next to it, and this isn't going to be a problem 10, 15 years down the road when people are saying, why do we have a junkyard in the middle of our neighborhood?
That's what they'll be saying.
Well, actually, let me address that.
Okay.
It's an appropriate location because it's in the ag area, and we allow a lot of uses in the ag area that are not appropriate in the urbanized area. I think we went through a long, tedious process with mining. It's another use that's allowed in the ag area, and people who go and build houses and move to the ag area have to be aware that they could be living next to a pig farm, a grove that's using chicken manure, a mining operation, or a use like this. Okay. So I think it is appropriate, given the context, that these types of facilities have to be somewhere, and this is on an arterial road. It's close to the landfill. It's in the agricultural area. Right now there's nothing around it, so people will be aware if they want to do 5-acre ranchettes that there will be this. And plus, we're trying to put in safeguards to minimize or mitigate any off-site impacts.
And just add, I think one of the other factors here is that there's an existing kind of agricultural, industrial, building on the site. It's got a history of something other than strictly ag, and certainly residential on it as well. So I think either way, there's going to be some type of ag industry or packing house or warehouse, some kind of ag-related use that's not growing crops. So you kind of already have that historically on the site as well.
I'm sorry, can I ask one more question?
Please.
When I look at this picture, this overall aerial, and I see a thing that looks like an eye hook up in the upper left-hand corner, that's not something that's been platted for homes. That's not what I'm seeing there, is it?
Well, that is the south part of an affidavit of exemption. That comes off of the west end of, or actually comes off of 5th Street Southwest. That's further to the north.
Right.
So the answer to your question is yes.
Yes, there are 5-acre parcels that come off that are served by that cul-de-sac. You can see 2 of them basically on this slide.
What you don't see out of the aerial, and I'm pretty sure I'm correct, is there's also a packing house, a rather large packing house just to the north and the west. I think that's a retention pond that you see in the corner of the picture. So
doesn't make as much noise.
Okay. Thank you.
Unless you live next door to it.
I have a few questions. When the roll-on gets tipped, does that get tipped into a bin, or does that just get tipped into onto the ground and then a bulldozer moves it to a bin, or how does that work?
I'm going to let the applicant clarify that, but I'll tell you how, as I understand it. As I understand it, the DEP requires it to be tipped on a hard surface, so it can't be tipped on a stabilized surface. So it has to be tipped on something like concrete or asphalt, from the standpoint of just making sure stuff doesn't get into the ground readily. From there, it's sorted, and there are a variety of different operational ways to sort that. Some folks have hoppers, some folks use machinery, some folks use hand sorting, and from the operational standpoint, I don't know exactly how they're going to achieve that.
Okay, then I'll ask that of the applicant. Another thing, dust control. Is that dust control for the recycling or dust control for the debris, the demolition?
It's primarily for the processing. Either the mulching or the concrete crushing are the 2 things we anticipate will generate the most dust. It could be under certain conditions, especially when you have windier conditions. If you have stockpiles of material, you may then start to get the debris from just the actual debris blowing off the stockpile, in which case they'll need to take measures to address that as well. But it's primarily from the processing, but not entirely limited to the processing.
Okay, so we have a lot of dust from the crushing of the concrete, and then we will also have the potential dust from the piles of concrete. All right.
Piles of concrete or mulch, either one could.
Even a junkyard can't go more than 8 feet high. I mean, what they store inside it. It cannot go beyond the height of the fence, I understand, or beyond the height of the buffer.
I believe that's it. Criteria is in the
All right.
junkyard, right?
But here we're looking at approving 25 feet. Do you see a conflict there, especially with dust control, too, of being 25-foot high?
The 25-foot standard has been applied to Mr. Mulch, which is a more similar operation dealing with materials of a similar nature, one being identical to wood. And that is based on a fire department criterion.
Well, the wood is because it's combustible. I don't know if concrete dust is. Yeah. Okay, they're the only questions I have so far. Oh, yes. What is the buffer, the wall being constructed of? Is it wood or is it concrete?
It's shown as a wall, which would be usually some type of masonry.
Okay.
Maybe a precast or a panel.
I would just want to make sure, because we have a problem with wood fences. Gentlemen, you have any questions of staff?
No, I'd just like to add that in the mining regulations, they had all the stacks. I'm sorry. In the mining regulations, they had all the stacks up to 25 feet. And, of course, we have a dust control plan that will go ahead and keep the dust out of the neighbors' yards and out of the roads, et cetera, et cetera. Maybe that's something they might want to look at in reference to dust control for this project. And I think it should take care of it,
Do
really.
you use a sprinkler system for that?
We'll be using one.
You will be? Okay. I know that's what the other mine down south uses. Okay, this is a public hearing, so I will open this up for the public. Is there anybody who would like to address the commission on this? Sir.
I'm Robert Combs, 396 West Tangerine Square, Southwest Vero Beach. I'm representing here to find out about the rules and regulations, which this gentleman has pointed out, for my president and vice president of the Villas of Citrus Springs Property Owners Association. We're one of the associations out of 8 that are within 0.4 miles from 58th Avenue and Oslo Road, where this proposed plant is going to take place. And I'm suggesting that it has more negatives than positives. Oslo Road at that point is the original road width, which is one-way lanes each way. And I drove on the property myself to look at it. And it's very dangerous to pull out of that complex and take a left or right turn, even though they'll have an exit and an entrance on the property. And I can see Tractor Trail is having a heck of a time executing the turns and not going off into a ditch, and traffic avoiding contact with these vehicles. It's a very dangerous situation there. Yes, Oslo Road, maybe 5, 10 years, 15 years might be widened, but until that time, we feel it's a very dangerous situation. The mulch and compost also is an environmental problem. The noise of the machinery to crush the mulch and the trees and whatever materials are being brought in there by truck. There's going to be fine dust particles and odor created by these, and when they're stored in piles up to 25 feet on the property, hopefully they will be on cement or blacktop platforms, so it does not seep into the groundwaters. Piles like that might be stored for a number of days, possibly months. With the hot sun and the rainy season here, the waters will get into the mulch and compost, and the heat of the sun will create spontaneous combustion, which can lead to fires. And from my own experience on Long Island, I'm a volunteer fireman, For 20 years, we've had mulch fires in town dumps, and it would take many fire departments and many men and many days to put the fire out. Concrete crushing, bad news. You have a big monster piece of machinery that's going to be grinding away all types of concrete. There's definitely a dust pollution contamination that's going to go into the air. Again, we're only 4/10 of a mile from 101 residents of Citrus Springs, but you also have many other condos and in that whole area just south of Oslo Road and east of 58th Street. Many people are in there, brand new homes. I've been there for 6 years out of the 20 that I've lived in Vero Beach. Traffic, you have many trucks going up and down Oslo Road now, and since I've been there for 6 years, the traffic of coming off 58th, 43rd, and 82nd, coming down Oslo Road, it's bumper to bumper for at least a mile before Oslo Road. Not Oslo Road, I'm sorry, 58th Avenue and 43rd Avenue. So this traffic congestion is going to be added. There's going to be too many trucks coming on the road to add to that problem. I was going to ask about the investigation that was going to take place due to what was mentioned in the press journal. That's the only way we found out about this, by the way. True, it's probably been noticed in the paper and all. This is all new to the county. There's a lot of investigation and procedures that have to be accounted for, and I don't know the business background of this particular company. I would say it's going to cost quite a bit of money to set up a proper, within the laws, business there. So whether their background in business is good or not, I can't say, but it's going to take a tremendous amount of money to create this facility, and we are against it. Thank you very much.
Thank you very much, Mr. Combs. Is there anyone else that would like to address the commission? The applicant like to make a presentation?
Can I ask a question of staff?
Anytime.
Yeah, thank you. There's a gentleman, we just heard from a gentleman who lives around here, just said there's a compatibility issue. There's a section in here that deals with compatibility, but I don't see anything in this section about compatibility that deals with surrounding residential neighborhoods. So I was just wondering if you'd like to take this opportunity to tell us a little bit about that. The compatibility, normally when I hear about compatibility with an existing use, it means, what do the neighbors think? Have we heard anything? Have people come in and talk to you about this who live in this area? Do you have any thoughts about it? Is this compatible in that regard?
Well, yeah, and I think that's actually why John had the one slide on compatibility issues, and we had that little section in the report. We looked at noise, we looked at dust, we looked at visual. And part of it is a question of how far away and what uses it is. Bob talked about the agricultural area that the zoning goes all the way to 58th Avenue, which is more than half a mile to the east. And then to the east of 58th Avenue is Citrus Springs. So part of it is a question of how far away, compatible with what area. John can speak to this. We've sent out notices. It was published in newspapers. And John, you can comment on whether we've gotten comments from any surrounding owners.
We have not received any calls on this particular, and we sent out, I believe, about a dozen notices, and that no calls or comments on that. There was the article in the newspaper. I didn't receive any calls relative to that.
Mr. Biddle.
Joe DeBiddle, Shulke, Biddle and Stoddard, 3 Tarpon Drive. I'm just up here to answer some of the questions y'all may have. I don't know if you want to ask me the questions, or I've done a little list of some of the comments. what's better.
I just had maybe comments more than questions, but knowing where this site is and what it's been used for historically, I mean, it was a packing house at one point. So I distinctly remember seeing, excuse me, trailer loads of fruit going in and out of there, pulled by semis, or called semis. And I realize there's more traffic on Oslo, but we have, you know, that problem everywhere. It seems like to me, and I don't want to challenge the homeowner, but it's a mile from 58 to 66th, and this is less than a quarter of a mile from 66th, the site plan. So it seems like to me that it's not a quarter of a mile from Citrus Springs, but more like 3/4 of a mile, or a half at the minimum. And I think what is our criteria for notification used to be 300 feet. So this is well outside of the criteria area that you would have had to notify the people at Citrus Springs. And I understand their concern. I see it as a good use for the property. I'm sorry.
Okay.
I agree.
Can you tell us a little bit about the process, Mr. Biddle?
Yes, as John stated before, basically the trucks will come into the site. Just to let everyone know, we have to go through DEP solid waste permit, which is a substantial permit. The county doesn't really have it. We've tried to, as John stated, trying to work through this in the process to see if the county has a solid waste permit, whether we have a franchise agreement, all this stuff. The DEP is a controlling factor, as with the salvage yards and all that. We have to get permits through them. We have to adhere to all of their requirements, which are substantial. So with that, coming into our site, we have what's called a processing area, where basically the trucks dump all their loads. And from there, we sort it out, whether it's heavy equipment or manual, depending on what the load is, could be any different type of load. We just don't know.
So it would be bulldozers moving the
Possibly, if it's heavy concrete. I mean, we're trying to help the community by recycling the concrete rather than sending it off to a landfill. So once it's sorted, the DEP has what's defined as leachate. Everything that comes into the site and just dumped there, if any rain touches that, it's called leachate. But once it's separated, it's called a product, and then it's legally it's a separated product. You don't have to deal with leachate. It doesn't get into the groundwater and stuff like that. It's a separate product. So we have a designated process area, which is right behind the existing building, which is a firm concrete area, and we have to deal with ground watering, storage, and all that. That's where we have a separate area.
Is the separation done inside the building, or?
No, it's outside the building. There's a concrete pad. I don't know if you've been to the site, or if John wants to throw it on show a picture on there, but it's in the rear of the building. There's a large concrete pad we're pouring.
What's the building used for?
Mainly office, and then if they get cardboard, storage for that, and also for sorting, recycling.
Are the individual contractors the ones who will pack up the trucks and bring them out and deliver them to you?
Yes.
And so they're responsible for, I assume, putting on-site waste into these trucks, and you really have no idea what you're getting.
That's what John alluded to, where if we have hazardous waste or tires or something that's a byproduct, obviously when you're doing a demolition site, most of the time these people don't care. They just throw everything in, unless they're separating and have a purpose. So everything that comes in, once it's sorted, we actually have a loading area just to the west of this processing area, is where anything that goes to the landfill, that's where it's placed, and it's sent off to the landfill.
And how will you identify potential hazardous waste as it comes off the truck?
I'm no expert in the field, but I assume they're mainly looking for recycled materials that they can use. I assume anything else that's not part of those recycled materials, whether it's hazardous waste or not, they will, that's what goes to the landfill. Obviously with hazardous waste, I'm sure they have testing and they're familiar with the industry to see what that would entail, but I'm not sure if they can spot it or... Good.
Can you speak to the issue of fire exposure and mitigation?
Well, the piles that we're going to have, as with the mulch that John spoke about, everything is with, we do sprinkler systems, and you're watering it. You have to water it a certain amount of time so it doesn't get dried out. That's just a standard DEP requirement. That's why everyone's allowed to have these permits. You just can't let it sit there and pile up and ignore it. There are protocol for having this permit and what has to be done.
Any further questions of the applicant?
I guess, in regards to the concrete crushing, what is the process on that? Is that going to be crushed wet, or is it going to stay dry and be crushed?
I'm not sure if it's wet or dry, but the concrete crushing, as of right now, they will be hiring someone to come in with a crusher. I mean, this isn't something that's running every day, all the time. It's when they get concrete, that's when they'll have it done.
I was just asking because the dust issue of the concrete as you crush it. If it's wet, of course, it's going to be less. If it's dry,
yes. And the dust suppression and everything, obviously, with the DEP permit, they require that we have to deal with that situation. That we will have to have dust suppression. We will have to control dust from concrete.
Would anyone like to ask questions of the applicant themselves?
I have another question just for fun. What do they do with crushed concrete?
I believe it's sold off to recycle, to
road base.
We'll let them speak about it if they have any questions, but you can sell anything these days, so we're just trying to recover some of it. Some of the other little items, I know John said that the landscape buffer, the 8-foot opaque feature is not a noise. I believe it will be. I mean, everything else in our code at a maximum is 6-foot opaque features. When you have subdivisions separated from roads, arterial roads, this is the first time I ever heard of an 8-foot opaque feature required in the county. I think it will be substantial. One of the reasons we did a berm wall combo, we do a 4-foot berm with a 4-foot wall, and so we don't have the echo. Because if you have an 8-foot wall around the entire perimeter, I'm sure we'll get echoes, but with a 4-foot berm, we hopefully will decrease some of the noise vibration. Also, we have a substantial landscape buffer required around the entire site, and I can only imagine that will help with the noise also.
Did you want to speak to the applicant?
I'm done. No.
Okay. Anyone else? Okay, is there anyone else who would like to address the commission? Please come up.
Good evening. My name is Louis Schacht. Reside at 2260 Vero Beach Avenue, Vero Beach, representing Schacht & Company Incorporated. We own the property immediately west of subject property. Just a few quick things. We are in favor of the project. Do believe that this sounds more like an industrial venture than an agricultural venture. And to me, when I look up and down Oslo Road, from 58th all the way to the potential 95, exit there. To my knowledge, there's not a single-family residence along that corridor, but there are a handful of industrial projects, exchange packers, the new ocean spray, and I just think that the county staff ought to look into a potential industrial corridor there, really call it what it is, and attract an exit to this county. Thank you.
Okay, let's rezone ag to industrial.
In that area.
Okay, is there anyone else who would like to address the commission? And seeing none, I close the public hearing. Okay, I want to go back to my screening the recycling material. In industrial uses, the criteria for recycling centers is that all stored recycling material must be completely screened from adjacent properties and road rights of way. So I'm really a little upset that this can actually be 25-foot high stacks of trash, when even in an industrial area we require that it be totally screened. So in an agricultural area, I don't know, I guess we allow it in mining, but that's a mining operation. So I have an issue with that. Also, definition section under demolition debris site is property utilized by special trade contractors primarily engaged in wrecking and demolition of buildings and other structures. I'm not even sure the demolition debris thing fits in here. Those are my comments. Gentlemen? We have two votes then to make. One is a special exception vote, which will allow the demolition of debris. And then the second vote will be the administrative permit, which will allow the recycling center. We do special exception first because the recycling center will, the debris removal, the demolition of the debris has to be approved first before we do the recycling, if I remember correctly.
I move to approve the
Special exception?
special exception.
Actually, the motion, I think, should be that you move to recommend to the Board of County Commissioners that they approve.
I move to approve staff's recommendation to approve this to the Board of County Commissioners.
Do we have a second?
Second it.
All in favor say aye.
Aye.
Opposed? Okay. Now the recycling center, the administrative permit. Do we have a motion for the administrative permit?
Yeah, I move that the P&Z Commission grant administrative permit use for the approval of proposed recycling facility, subject to the County Commission's approval.
Second.
Second.
Sorry.
Okay. Dr. Day seconded. All right. Any discussion? All in favor say aye.
Aye.
Opposed? Carries. What thing?
Contentious one. I think I grabbed it. I want to keep it like this. I think I put it over here and it was
Okay. All right. Commissioners' matters? Planning matters?
Just one item, since we've got till 11. No, not fun? Okay. Just since your last meeting, the Board of County Commissioners did approve in January the PD modification to Point West for the school site, consistent with your recommendation, and that's all that I have.
Excuse me, we still have a meeting in session. Henry, put your phone away. Jeez. Okay, that's Commission Attorney Matters. Okay. Adjourn. I can't believe Henry.
I did. It's got my notes on it. Thieving my paperwork.